Okay.
Okay, good afternoon. This is the Board of Standards and Appeals Public Review Session for April 20th, 2020, 2 p.m. session. I'm going to read the cases that were adjourned or postponed for April 2021. The following cases are 5597BZ, 7636 164th Street, Queens. This is postponed 2018-30A, 40 Flatbush Avenue, Brooklyn. Adjourned is 2017-21BZ, 3438 38th Street, Queens. Adjourned is 2018-192BZ, 229 Lenox Avenue, Manhattan. Postponed is 2019-66BZ, 15 Terrace View Avenue, Manhattan. And adjourned is 2019-184BZ, 4520 83rd Street, Queens. Those cases will be rescheduled for a different date, and everyone will be notified. So for the 2 p.m. review session, the following cases will be discussed: 2017-1619A and 2018-105A. This is for Clintonville Court, Queens. 2018-201A, 46 Kissel Avenue, Staten Island. I believe that's the appropriate pronunciation. 2019-195A and 191 Industrial Loop, Staten Island. 2019-6BZ, 138 East 39th Street, Manhattan. 2019-7BZ, 3341 Country Club Road, the Bronx. And 2019-76BZ, 1973 East 16th Street, Brooklyn. This is a public review session. Please do not call in. The first, start?
Yeah.
Item number 1 and 2, 2017-1619A, Clintonville Court, 2018-105A, Clintonville Court. Various addresses, sorry.
Okay. As of right drawings, can you hear me well? Just making sure. As of right drawings, relying only on a GCL 35 waiver, show 4 semi-detached houses were provided. The site plan for this version is very basic and doesn't explore creatively using staggered flag lots where the houses could actually be a combination of semi-detached and detached with complying 8-foot and 5 and 8-foot sides yards respectively. In that way, the alternating houses could be set back deeper on their lots and make better use of the lot depths as other houses in the area have done. I also don't see any mention at all about a development that pursues access to the rear of the site from 150th Place onto mapped and unimproved city-owned Lot 32, continuing on to the map street that is the subject property, was something that we asked for. There is one unsupported statement that Lot 32 can't be developed because it is city-owned. Yes, it's correct. It can't be developed. So that's the whole point, that you're using that as a street. It's a city-owned map street. But it can be used to access a private property that fronts on the map street. I'd asked at the last hearing for a design that pursues that route and which would then only need a GCL 35 waiver, but nothing was provided. That seems to have been just ignored. One could argue that the hardship of the deep lot complained of here, Lot 21, is self-created since it is the bed of the map 16th Road, which runs through from Clintonville Street to 150th Place. And many of the houses listed in the land use study submitted on October 1st, 2019, are well under 0.5 FAR, some on lots much larger than those shown on the as of right provided here. There is no requirement that all of the floor area be utilized on a zoning lot. And in fact, the underutilization of floor area is typical throughout the city, not just in this area. At the last hearing, we also asked for an argument that might distinguish this case from our decision in Nello Court. Nothing other than a tax map purporting to show the Nello Court site was provided with a simple statement that the 250-foot depths of two of the subject lots versus the 210-foot depths at Nello Court is the difference, without explaining really what the difference is. And of course, there are a lot of issues on this site that were not available on Nello Court, like being able to access the site from the back using a map street. We have, I believe, all of the restrictive declarations in and access agreements in order for us to be able to move forward if we chose to on this one. But I do have problems with this because they haven't explored as of right options that I think actually would be better than the proposed. And those are my comments. So, sorry, just a second. So Commissioner Shanda.
I was satisfied with the documents that were submitted and the applicant's explanation of how the surrounding areas and the homes that have been developed and the typical lot depths and how these lots are atypical and that an as of right development is not viable. I will respectfully disagree with Chair with regards to providing access from 16th Road. It is city-owned site, and even having to use that lot 32 to access the site would require some kind of an agreement with the city, whether that is through easement or whether that is through anything would require some kind of a land use action. It's not just allowing an access, somebody walking through that road or even driving through that road. So I do not think it is an as of right. It does merit some additional review process, discretionary review process. And so I think what the as of right proposal that has been submitted is very much kind of similar to what is built in this neighborhood. Buildings are built to the lot line, except for few that have some buildings that are in the rear. But by and large, all of the lots are along the lot line. And what the as of right showed was that. And so I'm satisfied with the proposal and the submission.
I have a question. I don't actually understand the statement about a further action. It's a map street and it's city-owned land that's occupying that map street. So I don't understand what other action would be necessary. I don't get that. You have city-owned land.
It would require city to build that site. I mean, which city is not going to do at this point because it has no reason to, I mean, at least it has not expressed any desire to build that portion of the street. And to provide access would require the developer to build that portion of the street just to access two homes. And I don't see it resulting in a better site plan. It would be the similar site plan that they have. Any different, I would say it wouldn't result in a different site plan. It would be similar one without a cul-de-sac coming from Clintonville. It would be from 16th Road with an expense having to build two roadways, one through Clintonville and one through 16th Road. So I'm not sure it results in a dramatically different, better site plan. It would be very similar, just without an access from 16th Road.
So I'm very confused because this is a GCL 35 waiver also for the right to build in the bed of a map street. So lot 32 or whatever that lot number is it, yeah, lot 32 is in the bed of a map street. That's what lot 32 is, the bed of the map street, and it's city owned. It's not a city owned lot to develop for another purpose. It's city owned land sitting in the bed of a map street. It's already been designated as a map street. So I don't understand what possible other action there could be. And every developer is required to improve the roadway that accesses their lot. That's what a builder's pavement plan is for, sidewalks plus the width of the roadway. So I don't think that's accurate. And so the idea would be that you would be coming from 150th place onto taking a right onto Clintonville, whatever it's called. Taking a right onto that map street, that's just an unimproved map street, and then you pull into your own property. So you're staying on mapped land, and there's less that needs to be granted the GCL 35 waiver because you're driving down a map street that's currently unimproved that you would be improving. So these two things are crashing up against each other. But maybe take a further look at that because I don't understand those comments. But I'll go on to Commissioner Otley Brown.
Hi, I was looking on it at the project based on land that they currently own and not based on having to purchase an additional site. And I don't understand what would be wrong with granting the GCL 35 because it would result in 4 homes, semi-detached homes, but still 4 very nice large 2-family homes that front on a map street. So I don't see anything wrong with actually granting that for them because there would be perfectly fine access from a map street. And so the idea of public safety and fire safety, those findings would be met.
Right.
So
Yes. This,
fine.
okay, but this is a dual application, both a 36 and a 35.
Yes, and I think that it's probably superior to the combination GCL 36/35 waivers, because then you do have the access issues getting to the rear lots. And while, yes, you're right, they might be able to persuade the city to sell them the land. It's, excuse me, in the back so that they could have access to the rear to provide development options. I didn't analyze it that way because I don't think that you can force an applicant to purchase additional land. So I looked at it as based on the land that they actually have on their control, what would be a fair type of development. That's why I think that a 35 would be fine.
Okay, I agree the 35 is fine, but again, this is city-owned land on a map street. So they don't need to purchase it. They just drive down. They just need to improve it because it's not paved, right? So the idea was they would drive down lot 32, which is the portion of the map street that doesn't need to be DMAP because that would be their access route. And it's publicly owned map street. It's just not the
Right.
whole, not
But
on their land.
Right, but they would have to pay to improve it.
Yeah. Yes. But that's true about all builders pavement plans, right? You always have to improve the street bed in front of your property.
Right, but in those cases, when you own that lot, when that's part of your tax lot, that's another story in terms of you expending the money to develop something that you actually have title to versus spending your money on something that you don't have title to, which is the city-owned lot. You don't have title to the city-owned lot.
But all builders pavement plans, when we're
No,
not in this
I'm talking
GPL
about
land.
Commercial builders pavement plans that we were talking about. The ones where they own title to that lot and they're building it out for access.
Okay. But like, if we just don't talk about a GCL case, if you just talk about any development on a new site, like our variance applications, they're required to improve to the middle of the roadbed, the publicly owned map street, or, right? That's just what a builder's pavement plan is. So in this case, and most of the time we have these, like you said, theoretical builder's pavement plans. But this
Right.
one wouldn't be theoretical. This one would be an actual because lot 32, for whatever reason, it has a lot number, is a map street. So they would be paving to the center line or whatever is required by DOT, however that works, that little portion of the map street.
True, you do have a point there. I just hadn't looked at it in that way.
Okay. Oh. Commissioner Sheta? Oops, sorry.
Compare the two proposals, the one that's initially submitted, the proposed plan, site plan, and the currently submitted as of right. And I believe the bottom line of this is the number of houses that could be built or that they want to build on this site. The proposed plan, site plan, I believe it gives like 5 houses. The as of right that's submitted, this current submission is just 3. And
Oh, it's 4. No, 4.
yes, I'm sorry, yes, 4, yes. And when I look at the 2 of the properties that I'm talking about, the 2 to the north portion of the site, if you look at these 2 and you compare them to other houses to the north of the site, they are not out of character at all. I can see like 1, 2, 3, 4, probably 5 pieces of properties that already built, and they are similar in lot depth. So I'm not sure where the hardship is coming from. For the first 2 houses in the current as of right, yes, I could understand that. Yes, that the lot is probably deeper than other surrounding lots. But for half of the site or for half of the house counts, they are more or less like consistent with the character of the neighborhood. And in addition, that I did read the argument for the hardship like 2 or 3 times, and I couldn't really swallow that. So I believe if they elect, one of the options could be building the as of right, the currently submitted as of right. The other way is to, like the chair mentioned, they could go with and I'm not pushing them, I'm not forcing them. It's just a way to go. They could probably look into access from 150 place and get this through the city-owned property to the west. So I'm not sympathetic with the application in the form of the initially proposed site plan.
Mhm. Okay. Okay. And Commissioner Shibet, oops, sorry, there you go.
Thank you, Chair. I agree with you, Chair. I didn't see this as a very convincing argument. Their GCL 36 hardship argument, I share Commissioner Shetta's position on it. I really didn't find it revealing. Their separation from what their attempt to, well, we asked them to make an argument as to why this is different than hello. They did not. Short of that sentence that you mentioned, which again, I was wondering why it was there. I don't believe that I don't believe that we need to grant anything on this, because I don't believe they've really made an argument to grant anything on this. That being said, if the board does go in this direction of seeing a possible GCL 35, I would have to revisit that again. But at this point, I don't see any need to grant anything.
So even so they can't build all of those 4 houses without a 35, right?
No, I believe that they could. I believe the GCL 35 would be an appropriate grant for us. But
It would. Okay.
yeah,
Is that, you want to add anything to that? No.
no, I don't think I need to.
So Commissioner Shanda had her hand up first.
She's muted.
Proposed plan first, sorry. As I'm looking at the proposed plan, and if we were to allow access, if we were to, have the use lot 32 to provide access from 150th Road, I think. What I'm trying to understand is, are we trying to contain the density? Or are we trying to just see the absolute justification of 35 and 36 GCL, that is?
It's not about containing the density in any of these cases. It has to do with, do you have a hardship where you can't develop the lot reasonably without a GCL 36 waiver. You need to have a hardship. And there's unlike so many cases we see, there's another way into this site through a map street. So that's why I keep looking at it. And I think the project would lay out much better if you accessed some of the houses from Clintonville and some of the houses, one or two of the houses from a driveway that links off of the continuation of 150, well, right, the branch off 150th, whatever that's called. So it's, sorry, it's to build in the bed of Clinton.
So you're basically saying have
Road.
4 homes fronting Clintonville Street and have, and then one could have 3 homes approach from the roadway, 16th Road.
Well, they never applied, they never had 6, they had 5 houses. So in other
one-
words, you
one-
could
Well,
drive,
yeah, 5 that need GCL waiver because 1 does not require a GCL waiver. 1 is as of right. So
Okay.
here, this would allow 1, 2, 3, 4, 5 homes, as opposed to if we were to allow the access from 632nd, you could have a 4th home where the Clinton Court is, and then another one behind it, and then 2 more off of a driveway as they are today. So you will get more units if,
so I'm not looking at, I'm looking at, they're looking at having, so far they showed an as of right with 4 houses, right? And they were proposing 5 within our scope, right? And
right.
they could access going from 150th and taking a right on, I guess it's called 16th Road, which is the map street. They could take a right on 16th Road to their lots and then arguably pull into 2 different driveways that have adequate frontage on 16th Road. And the depth of that little lot 32 is very small, so it's quite a small road to develop in order to gain access to your own driveway.
So I have a question. So let's say if we were to, if we play this one out. So let's say we grant GCL 35 only, and that would not be for the entirety of it. I'm assuming some portion of the GCL 35. So I'm just kind of visualizing it. So if we were to open up the 16th Road from 150th, one enters from lot 32 onto the lot that that is backing against lot 32.
That's
Now,
lot 1, yeah.
right. So there are 2, there's a flag shaped portion of this entire tax lot. There, the applicant has proposed 2 homes with required 30-foot yard. And then the road will reduce to the width that would, I mean, are we,
This is,
I'm not understanding how that,
I'm not planning out their site. What I see is you can enter the site from the front and the back. And that there's a legal way of doing it without having to come to us for a GCL 36 waiver. You do need a 35 waiver because, you know, that roadway goes all the way through and takes up space that you could arguably be developing, right?
I think what I'm saying, getting at, is that you probably still will need GCL 36 waiver once you have the driveway in, because a portion of GCL 35 is going to be affecting the roadway that is in the interior section. So any home that is going to be in the the flagship portion of the lot will require a GCL 36 also. So I'm not sure how we are getting out of it.
Nobody provided me with a plan. So till I see a plan, I don't know what it is that you're not getting, right? I see access from the front and the back, and I don't see, and these GCL 36 waivers should be sparingly granted. And I'm not seeing that it's needed in this case, given the layout that they provided us, but I'm not going to lay it out for them. I asked them to lay this out and they ignored that instruction. So that's what that's about. Commissioner Sheta had his hand up and then Otley Brown.
Thank you, Chair. I believe, again, I repeat myself, and this is intentional. I believe the game here is the number of houses. And if we go with 4, if we go with the as of right that is submitted this time, it's 1 waiver instead of 2.
Yes.
And I'm not saying this is a variance. I'm not suggesting this is a variance, but because I'm engineer, I'm not that lucky. I use the analogy between the waiver and the variance. Both of them is we change the rules, the regulations, especially for a given case.
Mhm.
And like there is a minimum variance, I would say in this case, using that analogy of a minimum variance, it should be a minimum waiver too. If they can build without 2 waivers, just with 1 waiver, we shouldn't be granting 2. That simple.
Mhm.
So, again, I haven't gotten the argument that with 4 houses as of right, as shown, or maybe tweak a little bit, there is any kind of hardship. I can't see it. Why? Because there are similar houses in the neighborhood. Actually, I look at it the opposite way. If we allow smaller pieces of houses, that could be like a change in the character. If I have a big house and all of a sudden I see like a small piece of land that somebody's buying and is willing to build a house on it, I wouldn't be happy with that. Big house is big house. So I don't know why we should be cutting this site into 5 pieces if it could be developed just with 4 houses and they are reasonable.
Right. So the argument is that the houses are larger. Those long, narrow ones are larger, but I just think it's because they haven't worked out a design that makes the houses staggered or use the site better.
Yeah.
But then the other part of it is nobody said you have to be able to use all your floor area. And most of these houses, if you look on their chart, don't use all their floor area. So
Mhm, mhm.
it's not guaranteed right. I'm going to recognize Commissioner Otley Brown and then Commissioner Shabeta. I'm trying to get you unmuted. There you go.
There. I think if everybody seems like a GCL 35 is within reason, then perhaps the instruction given to the applicant should be draw up 2 site plans for GCL 35 waiver, one with access from 16th Road and Clintonville, and one plan that only has access from Clintonville Street, and then let the board make a determination as to which one they prefer. But just be clear to them that that's the only thing that we're entertaining at this point, and GCL 36 is off the table because that might push them to get creative versus just trying to give something back to us to prove that it won't work. This will force them to be able to be creative about it because that's the only thing that will work.
That's a good idea. Okay. Yeah. Thank you for that. That's a good idea. Okay. And now Commissioner Shabeta. Yeah.
Oh, I wanted to say pretty much what Commissioner Otley Brown stated. I'd only want to add this case has been before us for 2 years, since 2018. We have extensive discussions every time they actually do submit something and we actually have a hearing. We've been saying the same things about the GCL 36 for at least 2 years now. They haven't presented a hardship, and now they haven't said anything. They haven't made any distinction between this and Nello. I really think and it's not about density, it's about hardship and their failure to show any hardship. So I think that, as Commissioner Otley Brown stated, the direction should be to inform them to move forward on to see something with the GCL 35. And I don't think we should have many more hearings after the next one, if at all, after the next one.
That's a good point. I was looking at the history of it. We started this, as you say, in September of 2018, and it was adjourned 1, 2, 3 times, and we sent a dismissal warning letter in October of last year because it was adjourned so many times. And we've reserved time on our calendar on 8 times already, so you're right, it's enough already, so.
Madam Chair,
Yeah.
just one thing about the ownership of that street with that portion of lot 32. So DOT still gonna, because you had raised the question about they're taking jurisdiction. Well, they don't have jurisdiction now, but if they were to have to build out that street, then isn't there a process there? They're not gonna demap them, right? You're saying is they don't have to do that, but when they have to like lease or
No, no, no.
licenses?
No, I think everyone's misunderstanding. This is held in, the property is held by
DCAS,
DCAS, right?
yes.
So DCAS, being a city agency, is holding on to it for whatever reason it was originally purchased. It
Right.
transfers from DCAS to however that works, whoever actually owns the map streets. You know, it's either DOT or I don't actually know who owns the map streets, right?
I believe, I'm sorry, I don't mean to interrupt you, Madam Chair. So I had a brief conversation with DOT and they're still gonna look at this, but I believe right now they believe their understanding is DCAS still owns it.
I know DCAS owns it. But the point is, it's a mapped street held by the city of New York.
Right.
And what's DCAS own it for, right? They got possession of it and it never got transferred to the agency that's in charge of owning map streets. Like, I don't know if you were to look at title on map streets, you wouldn't be able to figure out who owns it. It's just known as a city-owned map street, right? You wouldn't find a deed that says this agency owns it. And you'll see like city-owned property with parks, for example, where DCAS owns it and eventually it gets transferred to the Department of Parks. Or DCAS owns it and it gets transferred to another agency to do whatever they do, right? So it's not like it needs to be licensed or leased or anything. It's owned by the city of New York and it's a map street. There isn't anything else the city has to do other than if it feels like internal stuff, right? I just don't, it doesn't really make any sense. Most of the time we look at it and we say it's a map street, but it's privately owned. That's a totally different subject, right? Then you have to talk about what happens to it and do you deed it? Do you convey it? Do you hold on to it as privately owned property that's mapped and improved, et cetera, right?
Okay.
Okay, and Commissioner Otley Brown, I mean, sorry, Commissioner Shanda?
Yeah, I think the process is not as simple as we are thinking it to be. If we really think this is the way to go, we should have a complete analysis done by our staff with DCAS and DOT as to how that would go through before we impose that as a requirement.
No, but so
No.
understand, it's not a requirement.
It will be, Madam Chair, it will be, because if city is going to allow a road to be built, it would then have to maintain it. And if it is not going to maintain it, it is going to require the applicant to maintain it. There has to be some terms of conditions or something that the owner has to take on to build, maintain per all the standard when it's a city-owned land. There has to be some transfer of some sort at the end of it. I don't think it is as clean as simple just because it is a city-owned land. I don't know the detail of it, but it is not going to happen just because DCAS owns it and DOT can take it over. DOT did not take it over and will not take it over. We know that for a fact at this point.
Well, they didn't take it because it's not a street, right? It's
And-
not approved as a street.
And that the street leads to nowhere. So DOT is not going to take it over, and DOT is definitely not going to maintain or manage the street for providing access to two homes. So if DCAS is going to say you want it, well, you'll have to buy it from us. We don't care.
No,
And I really do not think it is going to be as simple as what we think it will be. I would like us to have a much greater detailed discussion with DCAS and DOT if we are saying that this is a requirement.
So here's the thing.
But let's see, we see what the plan is that they submit here.
Yes, if they
That's
go
it.
ahead.
That's fair. That's fair. That is
If
fair.
they just go ahead and they pursue the GCL 35, however they lay the houses out on the street with access from Clintonville, then that's the way it's done. But I say that, we actually did have another case like this what was that one in Staten Island where it was up the hill? Well, that turned out to be privately owned property.
Yeah,
That we could extend. But anyway, I don't think it's our job to do this kind of investigation, except out of curiosity. This is the job of the applicant. If they
Right.
want to be able
Yes.
to use that access, then they need to investigate it. It's really not our job to do the work of a developer. Really, it's not. So, anyway, okay, I think we
Look.
talked this one through.
Okay. So we move on?
Yeah.
Okay, item number 3, 2018-201A, 46 Kissel Avenue, Staten Island. This is a review session. Please do not call in.
Okay. They provided a 2018 restrictive declaration for access easement on the driveway, which requires that it be maintained and kept unobstructed. The cover letter states that the interior flag lot that is this development site dates to 1936, but I don't see that on the maps provided. I'd like to know, what is the date of that linen tax map that shows the flag lot? They act as if the linen tax map is definitive somehow, but it doesn't have a date on what they gave us. The purpose of this analysis is to determine whether the flag lot is being used as required open space or otherwise by the buildings around it, or whether it was created, subsequent to 1961 and therefore essentially creates the hardship complained of. Section 25-22 of zoning resolution requires 3 spaces for each 2-family dwelling, and I only find 5 spaces on the zoning lot between those 2 houses. Parking isn't mentioned on the site plan, so there's no parking calculation. So it's not at all clear where the other spaces are. There are 2 in the garage, 1 in front of the garage, and then 2 kind of on the side behind the house that the existing house. We're also still waiting for sign off from DEP, and we still needed fire department sign off on this. Okay, so Commissioner Shanda?
I thoroughly enjoyed looking at these historic maps. I have to say it was quite impressive to do that. I really did not have any additional questions on this, but I was okay with it.
Okay. And Commissioner Otley Brown?
Excuse me.
There we go.
I don't have any additional questions.
Okay. And Commissioner Sheta?
Same for me.
Nothing further? Okay.
Yep.
Commissioner Shivetta? Sorry, 1 second. Taking a little bit of time.
I think we got it. Nothing further from me.
Okay, thank you.
Okay, next item is item number 4, 2019-195A, 191 Industrial Loop, Staten Island. This is a review session. Please do not call in.
Okay.
Damn, I'm a little long.
Sorry, new case. We have proof of service of initial application and of notice of hearing to officials. Community board recommends approval. The cover letter states that no builder's pavement plan is required for this site and refers to the attached waiver. The waiver states only that the DOT does not agree to allow construction of substandard sidewalks and roadways. Hence, the owner waives its right to sue the city in the event there are injuries resulting from the substandard sidewalks. This does not absolve the owner of constructing the roadbed to the center line of the street. So they need to provide a builder's pavement plan, and which, by the way, on industrial loop projects, we always see builder's pavement plans, and we always have a conversation about whether there's a sidewalk and whether they should create a sidewalk, and if they do, what it attaches to. So I find this a very odd statement because we always see one. In addition, the subject property owner is required pursuant to the 1995 restrictive declaration to pave and maintain the access easement. That's the deal. So even if it wasn't required by the builder's payment plan, it's required by the maintenance, by the restrictive declaration maintenance agreement. So you have to show that you're going to improve the roadbed. And I understand there's going to be a sidewalk anyway, so why put up all this fuss? Those were my comments. Commissioner Shanda?
I looked at the plan and I saw they were providing the sidewalks, which is what we have required of all the development in the last few years on industrial loop. So I was okay with that. However, I think that there's a little bit of an inconsistency in the statement of facts and the proposed plan with regards to the required number or of accessory parking and loading bay. So the applicant can look into that and make sure there's consistency.
What is it of what? Parking and loading?
Yes, yes.
Okay.
It's parking, accessory parking and loading bays, is that what you said, Madam Chair?
Yeah.
Okay.
Okay, and Commissioner Otley Brown?
No additional comment.
Okay. Commissioner Cheta?
Yeah, the only thing I have, I didn't see DEP. I'm not sure if we need that. Also, fire department, didn't see any feedback from them. Maybe I just missed it. And the other thing is the site is close to a waterfront and I couldn't see a firm map. Should they submit one?
Mm-hmm. Yeah. Okay. And Commissioner Shabeta?
Nothing further from me, Chair. I support your statements that were made.
Thank you. Okay.
Okay, next item, zoning calendar, 2019 6BZ, 138 East 39th Street, Manhattan. This is a review session. Please don't call in.
Sorry, my little wheel is going around again on my computer. That's
That's the mouse in your computer.
the Apple color wheel that goes around for unknown reasons for a very long time. I'm sorry. This is the time when we should break into song and dance, I guess, because we're on TV. It's still going around and I can't do anything about it. Sorry. Maybe somebody else wants to start because I'm just
Yeah.
watching my wheel go around. Commissioner Shanda?
Okay. So at the last hearing, we had asked the applicant to clean up the drawings because there were a lot of inconsistencies, internal inconsistencies between the drawings and the statements and within the drawings itself. We had asked that the BSA calculation sheet be provided and that the programmatic need was still not very clearly spelled out and that those documents needed to be provided. So the applicant has revised the statement of fact. More importantly, let's start with the programmatic need. The applicant has, in the programmatic need, it has described the difference in the seminary program and the rest of the church's activities in terms of what they do as a headquarters, which is an active center of religious and cultural activities, and that a number of activities that are held, and that many of these services are held not only within the facility, but most of them, by and large, since they're the group has extended the organization's group and the participantship has increased, that many of these activities are being held outside. So they need an average a room that can accommodate in excess of 50 people. So that is to justify the need to enlarge the space, and why that enlargement cannot happen on the ground floor because why can't a meeting room be held on the ground floor? Because they're proposing the meeting room on the second floor, which requires the waiver on the second floor in the rear yard. and their argument is that the conversion of the ground floor from office to meeting space would not be viable because the ground floor currently has low ceiling height, and which kind of does not make it an ideal site for a meeting space. So that's why they're recommending that the meeting space be on the second floor. Also, it's a security issue. By having the meeting room on the second floor, you're also providing an added security from the public street that it fronts. So those were the arguments that were made. Honestly speaking, I didn't look through the drawings in full detail to see every aspects were cleaned up. I looked through the elements that to me were important, and I mean what we are looking for, which is the rear yards and the height and the zoning calculations. They seemed okay to me, but I would leave it to the other commissioners to weigh in on this matter.
Okay, the little wheels stopped going around.
Okay.
So thank you for that. For the first time though, we learned from at least the cover letter that the project is a new building and not an enlargement of an existing structure. I have to say, I'm kind of astonished by such a statement. That's completely inconsistent with the alteration type 1 application that was filed in 2018 and the statement of facts. This is on the cover letter. It says it's a new building. There is no DOB application for an NB new building. And frankly, I think applicant's counsel who wrote, I think the statement, the cover letter is just wrong. The architect would be the one to cover this issue, but I just think it's wrong. The above is also underscored by the statement from the executive director of the institution about the low ceiling height on the first floor being a hindrance to locating the meeting room on that floor. That statement is also inconsistent with the statement of facts that says the floor joists will be raised for this gut renovation. So everything talks about an existing building that's going to be gut renovated. That is not an NB unless you take down all 4 walls, but that's not what it says in the statement of facts. It says that they're going to leave up the exterior walls. So I don't know. And I do have to say this application is far too small to have to belabor the topic of programmatic needs, but the applicants clearly aren't reading the materials they submit before they submit them. Here, the executive director says there's a security issue. So I'm picking up on what Commissioner Shanda said about a security issue about locating the meeting room and needing a reception area before entering the meeting room, which I think is labeled ceremonial room on the plan. So that there should be consistency about how things are described in a package. Instead of securing the first floor alone, security of the entire building is compromised by the proposal, since visitors will need to enter the stairs and the elevator to get to the ceremonial room on the second floor, rather than entering it directly from the street level. So I don't understand the statement about security. Perhaps the architect can join in and explain this. There are still mistakes on the zoning charts. There is no mention of the zoning district in which the site is located. That needs to be put on the drawings. The maximum allowable height for a permitted obstruction in a rear yard is 23 feet in 1 story, not 30 feet for a community facility, which is section 2433 and 2436. So that's an error on the drawings. The 3rd floor walls are not rendered the same as the walls on the other floors. So that's another error on the drawings. And those were my comments. So, but so basically, I just think it's a very sloppy application, but other than fixing those drawings, I don't really have a problem with it, except that I think it's sloppy. And I think there really isn't a great argument for why the ceremonial room needs to be on the 2nd floor, which raises the height slightly. But not really, because if I'm correct, it's not even high. It's like 23 feet high in the rear yard. It just has an interstitial floor, which you could have as of right if you didn't have that interstitial floor, I think. without going back and looking at the drawings. Commissioner Otley Brown.
I agree with you that it is pretty minor application. It's just allowing for them to have that second floor and the rear setback. But unfortunately, the arguments that they raise to justify it really don't ring true, because they say that it needs to be on the second floor because the first floor's floor to ceiling heights are low, yet they talk about how they're lifting the whole building and doing this great structural alteration. That means that you can realign your floor joists. As
Right.
far as I look at it, I mean, we've seen that happen in private homes all the time. So it couldn't be that terribly expensive if even private homes are undertaking that. So that being dismissed, it kind of weakens their argument for why they have to keep that first floor as is. I also think that you can very easily relocate your executive director's office and your other small offices up to the top floor in an as of right floor. So I'm really not buying that argument. The only argument to me that remains is the security of the first floor argument. And I mean, it would be very easy to poke holes in that one in the same way that you did. I'm trying to give them a little deference. I wish they could tighten up their arguments in one way, shape, or form.
Mhm. Okay, yeah, agreed. They actually do say that they're gut renovating the building, so they're obviously raising the floor to floor heights. And they see, yeah. Okay, and then Commissioner Sheta.
I don't have anything further for what is said so far. So
Commissioner Shibeta. Sorry.
So this application is frustrating because it's such a small ask, and frankly, I wanna let it through, but not as much as I want to remain consistent. And I hope that during the hearing they can convince us somehow that these things are needed, rather than like this really transparent argument that doesn't hold water.
Mhm. I mean, I think the main, I don't have the drawing like right in front of me, but I'm pretty sure that the height of the rear addition is 23 feet. It's just 2 stories instead of 1 story. So you wouldn't notice the difference. It's just that they make such a weak argument for what they need. But otherwise, you could have a 23-foot high 1-story addition at the rear. I'm pretty sure I need to open the drawings, and I don't have enough screens to do it right at the moment. But okay, any other comments on this one? Okay.
Next one.
Mhm.
Item number 6, 2019 7BZ 3341 Country Club Road, the Bronx. Once again, this is a review session. Please do not call in.
Okay. Basically, we're in environmental review mode. We have open WRP. City planning still needs updated WRP consistency assessment form. We have open hazmat. DEP approved the phase 2 and the work plan and the HASP with modifications. So applicants should proceed with the phase 2 testing. But we do have sign off on natural resources and LPC. But just to note that DEC, on the other hand, because I was concerned about that, has no objection to BSA issuing approval prior to DEC issuing permits, but wants us to be aware there is a chance that the site plan might need to be changed a little during their review. And their concerns would likely be about the lines of the pier and float sizes and construction methods. So the applicant needs to be aware that if we were to approve this and DEC wants changes made, they would have to come back to us either for, and we don't know which, either for a letter of substantial compliance or actually an amendment to the application, and therefore a hearing. So it depends on what the scope of the change is that's requested by DEC. And DEC may not be the only agency reviewing this, right? This is coastal, so it's Army Corps, et cetera, I think, as well. Any other comments? Commissioner Shanda? Turn off
Something just went. No. So somebody called. I thought I turned my speaker off, but not. No, I did not have any additional comments. I had the similar concern with regards to DEC's recommendation and notifying us that there might be some change in the plan. And, in terms of the plan, the revised plan, they have accommodated all the recommendations that we were asking for, which is providing the fencing, planting for the buffering, and the fencing be of superior quality. All of those were indicated in the plan. But yeah, should the applicant go forward, they need to be mindful of the possibilities of the change that would be required.
Right, and the potential cost if they have to.
Yes,
Mhm.
yes, yes.
Commissioner Otley Brown,
No comments.
Commissioner Sheta.
During the last hearing, we asked them to submit an elevation with the tidal elevations on it. I couldn't see tidal elevations shown. I'm not sure even if the submitted elevation is the one that we asked for. The other thing is the drawings that they submitted this time are just separate drawings. They haven't submitted like the entire set.
There
So
is no set. It's just a one-page drawing. They ended up combining everything onto one sheet because I looked for that also.
oh, okay.
So
Okay.
they used to have this tiny site plan. They blew up the site plan to include everything. And then there's the section to the right on the site plan.
Right. Yeah. Right. Yeah, I noticed that. But did you see any tidal elevations shown? Because I couldn't see them.
I don't know. I need to look again. So I'll check. Okay. And Commissioner Shibeta.
Nothing further from me on this.
Okay. And Commissioner Shanda had her hand up.
So I think on April 1st, the applicant submitted an elevation which shows the design flood elevation, the flood height, and is that what you're referring to? Or
I just opened that. That was submitted April 1st.
yes.
Oh, for some reason I didn't see it, probably because I looked at the folder before March 26th. Yes, but I see an elevation view with, yep, I got it. Yep, it's there, yeah. That's what I'm talking about.
Okay, good.
It has the DFE, the flood high, the flood low, and the mean high water level, yes.
So that's what
Thank you.
That's what you were looking for then. Okay, good. Thank you. All right.
Next item is 2019-76BZ, 1973 East 16th Street, Brooklyn. Please do not call in.
Right. And my wheel's going on again. So Commissioner Shanda, would you please go? I have to
Sure.
say another way.
The applicant in its recent submission of April 1st provided a revised plan, and in the revised plan they are showing the legalized existing condition of the first floor with the additional enlargement. And the plan also indicates that the existing garage will be removed and the southern side yard would be increased to 6 foot 5 inches to a total side yard width of 10 foot. And there is no change to the building height, and the total floor area is then reduced to 2,185 square feet, which is about 0.73 FAR. the revised existing plan, there was an error supposedly in the floor area correction. So they revised it, and the existing floor area is 2,208 square feet. I couldn't actually, I have to say, I was trying to locate the error in the existing plan. I couldn't locate it. So if the applicant can walk us through what that was, that would be helpful, especially given the fact that we are trying to legalize an existing condition.
Mhm,
So it would be good to know what that is.
mhm.
But that's,
Okay.
yeah. So I will let you take over and then I can give.
So my wheels stopped. So yes, the project was dramatically revised. So now we're only looking at a first floor extension. We originally had problems with the depth of the second floor extension, which is no longer being proposed. And also there was a proposed increase in building height, which is no longer being proposed.
Mhm.
We had also asked for a survey, which they did provide. The proposed floor area now is less than the maximum permissible. And the total side yard widths now comply with section 23,461 and 2348 because it's a more narrow lot, so it gets a
Yeah.
reduced, total side yard. So if I have it right, the only waiver requested is the reduction at the first floor of the rear yard to 20'3" and the non-complying side yard continuation on one side of 3'8", but an increase of the other non-complying side yard for the extension of 6'5". So they're actually, for the extension, improving the side yard situation. There's a hatching, there is a mistake on the drawings. There's the hatching of the quote, area to be area to be legalized, which by the way, I had asked to be described as new construction versus existing instead, which is the way the Department of Buildings requires that kind of description. But anyway, that area to be legalized is shown on plans A1, A2, A3, and elevations A8 and A9 in one way, and then on section A11 in another way. So A11 is wrong, and that needs to be corrected. But other than that, I was okay with the proposal. Do you want to add anything, Commissioner Shonda, before I go on?
No, as you mentioned, I was okay with the proposed FAR. And the ask is, in this case, would be very much well within what we typically do encourage.
Okay. Okay, and Commissioner Lee Brown.
So I actually think it's a pretty modest ask, if not for the fact that they were legalizing it. And originally it was illegal. But other than that, I think that the FAR is low. The rear yard incursion's only on the first floor. I think it's a fine project.
Mm-hmm. Okay. And Commissioner Sheta?
Yeah, I believe the application the way it is right now is fine, and yes, I'm ready to vote on it.
Okay, great. And Commissioner Shibeta? I don't know why yours is hard to unmute. There we go.
Usually people feel the other way about it. But I think this is modest. Again, even though this is something that if it was an ask, it would be modest. I don't have any issues with it at this stage.
Okay, great. Thank you.
Okay, so this concludes the public review session for April 20th, 2 p.m. So we'll now begin with the public hearing portion for April 20th, 2 p.m. Do you want me to read the adjournment postponements again, Madam Chair?
Yeah, that's always helpful. Thanks.
Okay, so the following cases are adjourned and or postponed for the April 20th, 21st, 2020 hearing. 5597BZ, 7636 164th Street, Queens is adjourned. Postponed is 2018-30A, 40 Flatbush Avenue, Brooklyn. Adjourned is 2017-21BZ, 3438 38th Street, Queens. Adjourned is 2018-192BZ, 229 Lenox Avenue, Manhattan. Postponed is 2019-66BZ, 15 Terrace View Avenue, Manhattan. And adjourned is 2019-184BZ, 4520 83rd Street, Queens. New dates will be set for those cases. And the cases to be heard for hearing are 2017-1619A, along with 2018-105A, Clintonville Court, Queens, 2018-201A, 46 Kissel Avenue, Staten Island, 2019-195A, 191 Industrial Loop, 2019-6BZ, 138 East 39th Street, Manhattan, 2019-7BZ, 3341 Country Club Road, The Bronx, and 2019-76BZ, 1973 East 16th Street, Brooklyn. Please call in only when it's your case that is called. The first item is 2017-1619A, along with 2018-105A. This is Clintonville Court, Queens, and the applicant is Sandy Agnostu, along with Todd Dale. Todd's in.
Okay, there's someone in the waiting room.
Todd is connecting in.
Okay, and there's someone 979 guest.
That might be
That's-
Sandy.
It's here for Clintonville Court. Okay, state your name when you can hear us and turn off your YouTube video.
Sandy? I just saw Sandy. Oh, there she is.
Turn off your YouTube video.
Yeah, I have the video. I'm listening to the video now.
Someone, somebody with the last number 979, identify yourself.
My name is Phil Harris. I'm the architect for 1973 East 16th Street.
Oh,
Okay.
you're,
You're too early. Please hang up.
hang up.
Okay.
You're in the wrong.
Okay.
All
Okay.
right.
Okay, so we have Sandy and Todd.
Please,
Yes, I'm here.
please turn off your YouTube videos. We get feedback. Sandy,
There's Sandy.
there we go. Hi. Hi, Sandy.
I don't hear her.
Muted. I don't know why though. Why is she muted? Sorry, just a second. We're finding you to unmute you. Where is she? Here we go. No, you're unmuted. Speak. Nope, she's muted. I
Sandy,
don't
unmute.
unmute yourself.
No, she's muted still.
Unmute. Okay, here. Oops.
Oh.
There we
There
go.
it goes. Speak.
There we go. Sandy, go ahead. Now I think you muted yourself. We
can't
don't hear you. I don't know that you even have your mic on. You need to turn your mic on the lower left-hand corner of your screen. There's a mute versus unmute because we're showing you unmuted. No, we don't hear you. Maybe you know what you could do is call in and talk on your phone. Because it seems like your mic has been turned off on your computer. Can you give her the number to call in so she doesn't have to look for it?
Sorry.
You have to look for it.
The number is 646-558-8656. Sandy, you want to call that number? Maybe Todd can start, I don't know. No, he's co-counsel, but
Right. Sandy, the number is 558-8656.
The meeting ID number is 443-146-182.
I think that's the wrong meeting number.
No.
That's
That's
the
the
wrong.
wrong number.
I'm sorry. No,
Zero.
I'm sorry. I apologize. It's, sorry. 469-050-895. I apologize.
That's not right either. I don't know if, you know what, Kurt, is what's displayed here the ID number for once you dial in? We have a Zoom meeting ID and a password and a phone number.
Yes. So you call in to the phone number and then just put in the meeting ID.
The meeting 469-050-895?
Yeah.
Yes.
Okay. We always have a little glitch like this. Maybe we should be calling them when they can't reach us. I don't see anybody in the waiting room.
Oh, Todd left?
No, Todd's in.
Oh, okay.
He was. I don't know if he is. Todd's in, but
Yes.
no, nobody called in. Sandy, are you calling in? Maybe, Sandy, you could call Todd. And then you could be on speaker with Todd. Oh, there she is. Okay. Okay, we just admitted a phone number.
No, sorry, that was me. I was just testing.
Oh,
And it is the correct meeting ID.
okay.
Thank you.
Todd, can you give Sandy, please, and see if you can just have her be on your speakerphone?
I'm trying to reach out right now.
Okay, thank you.
Not so easy.
Sandy, you want to try speaking into your phone again? Todd is trying to reach you on the phone. Here we have another. There we go. You know what that is? You need to turn off your YouTube video. Wow. Turn off the video.
Someone,
There.
okay, can you hear me now?
Yes.
Yeah.
Identify yourself. Can you hear me?
My name is Phil Harris. I'm the architect for 1973 East 16th Street.
Okay,
that's
you
the
YouTube.
wrong-
You're too early. Please hang up.
Hang up.
Okay.
Okay. Okay, so you have Sandy and Todd?
Can you hear me now?
Yes, you must
Turn
turn
off your YouTube videos. We get feedback.
I feel like that's repeat.
Sandy?
Sandy?
Okay. Yes,
Okay, good. All right. Here we are. All right.
I don't know why you couldn't hear me before, but my mic was working. But anyhow, okay.
So state your name, please.
Sandy Anagnostou, representing the applicant.
Okay, go ahead.
So I listened to the comments earlier in the review session, and we did make a submission of an as-of-right plan waiving with only the GCL 35 waiver, which resulted in 4 homes fronting Clintonville Street. And they're very long homes on very lengthy lots, which are not in character with the other homes existing in that area. Also, at the last hearing, there was discussion about whether we could acquire use of lot number 32, which is city-owned property, and it's owned by DCAS. And it was my understanding that the board would reach out to DCAS to see if the property could be transferred to DOT. That's what was discussed at the last hearing, but the owner actually also reached out to DCAS, sent them a letter, and he had in the past as well, but he received no response. He sent a letter to DCAS inquiring about this. What Madam Chair is proposing is actually a nice solution, but it was our understanding that the board would be reaching out and discussing this, like one agency to another, if that was possible, and then we would move ahead. Hello?
Yeah, keep talking.
And then we would move ahead and explore that possibility.
Oh, okay.
And actually laying out a design for it. So that's what we understood. Otherwise, we would have provided that plan. In terms of the application taking the length of time it has, I just would like to remind the board that this application was actually on hold for a very long time by DEP because we had to obtain an amended drainage plan. And for a certain period of time, they had changed their policy, and this was on hold for a very long time before they proceeded and actually reviewed it and approved the amended drainage plan. And we also have the DOT approval and fire department as well. But we'll be happy to look at the possibility of accessing from lot 32, 150th place, and provide access from that as well as Clintonville Street. We just don't know how we can go about that since DOT doesn't actually own that.
No, but the city of New York
property.
owns it. One agency to another, it shouldn't be that big.
Yes.
You know, perhaps, and this is where Mr. Dale might have more experience in this subject because he really is more familiar with these kinds of GCL applications. Perhaps, Mr. Dale, do you have experience with how the ownership, how this works?
Sure. So Todd Dale for co-representative for the applicant. Just some background with respect to this. I do know when we spoke with the property owner, we weren't involved with the original application, but we were informed that in the past they had reached out to DCAS, and they were informed that if DCAS were going to do any sort of lease or transfer agreement, now that was not done with the city retaining ownership, but the initial discussions they had is DCAS said they were required to distribute it proportionately to any adjoining lot. So not just lot 21, which would be the lot owned under this property owner, but a portion would have to be transferred to the lot, which I believe would be to the north. Now I know that that's a title transfer. And what we're talking about here in this situation is allowing the city to retain ownership to it and then just getting rights to pave. In our experience, we've done this. This is not an unusual situation. There are lots of this type that are owned by various city agencies. And I think it's just important to distinguish the fact that just because something is mapped doesn't necessarily mean that the city has interest in seeing it developed forward as a street, and that ownership of the street and the mapping of the street are two separate issues and two separate factors. That said, every discussion I've had with the property owner, if this were a possibility, they would love to do that because it would provide some flexibility to the design and provide an opportunity to perhaps revisit how homes could, be placed on the rear portion of this lot. That said, the recent discussion, I think he just sent a message, fairly recently saying he had recently reached out to DCAS again and received no response whatsoever. So what I would put back to the board is say, the property owner would be willing to do this, but what would satisfy the board as far as a no response from the city saying that the city was not willing to have this access?
Well,
Like a letter or communication from a city agency?
right. So I'm not, somebody has to mute you have to mute your speakers, everyone. Please mute your speaker, Todd, also, and turn off your YouTube video.
Andy.
Turn off the YouTube video. I'm muting Todd because I don't know how to make the feedback stop. Okay, so we're not obviously interested in finding a no. We're interested in finding a yes, right? So what I would say is the first thing is, of course, everyone should be reaching out. Well, DOT may be the better way to go than DCAS because DOT has the experience with how this works. If necessary, if DOT for some reason, which doesn't make any sense to me, doesn't want to maintain that little slip of lot 32, which is hardly anything. It's like 40 feet deep or something. If they don't want to maintain it, the property owner could enter into a maintenance agreement and provide a bond like is supposed to happen on these GCL sites, right? But none of that makes any sense to me because it's a map street and it's owned by the city. So how is it that the city is not maintaining their own property? Makes no sense. The owner will pave the streets, that's done, and then the city should maintain the paved street. And this is the part I really don't understand because this is the reverse of everything that everyone's been talking about all of these years about these GCL cases. But so what I'd recommend is Mr. Dale and Ms. Adnagnastu reaching out to DOT and DCAS on your end, or your client doing that on your end, and we will put some queries out to DOT and DCAS about how that is handled. It seems like we're making a big deal out of nothing because it's a little slip of, frankly, useless land. The site can't be used for anything, right? And isn't owned by anyone who's developing it anytime soon. So I'm recognizing Commissioner Shanda and also taking the mutes off of Todd and Sandy. Okay.
As Mr. Dale pointed out, and that is something I had forgotten also, was that typically a lot of city-owned land would be under DCAS's jurisdiction. And when and if a city agency expresses interest in wanting to develop that land, then that parcel of land gets transferred over to that agency's jurisdiction. For example, that had happened with some of the projects that I was working on where either parks or HPD wanted jurisdiction, but they were under DCAS ownership. So DCAS would then transfer the land to HPD for HPD to develop housing, or transfer the land to parks when parks indicated that they had the capital to build the parkland. Until then, no city agency willingly takes over city-owned land because that means they have to maintain it. It's a budgetary issue. They will then take the money, that takes money away from their budget to have to maintain a land that they don't have any plans to develop. So that is why it has sat on DCAS, and that's really what DCAS's job is, to hold on to a lot of derelict city-owned parcel land that no other city agency wants to build on or use it for any of their agency purposes until and when they have the capital to develop it. So maybe that's one of the reasons why it never really got transferred to DOT and it sat on DCAS. And in this situation, when most of the pretty much all of the city land, all of the street bed is in private ownership, except for a very small fragment of it that is in city ownership. DCAS, of course, in that case, knowingly will not transfer it to DOT to build a road, but will then, as Mr. Dale pointed out, would divvy it up amongst the agency. They would probably reach out to two of the abutting agencies, abutting property owners, if they want to, take over, maintain, and whatever. I don't know what is the difference between takeover and maintaining the site as a map street. And DCAS, for that matter, would need to work with DOT to agree to that. Otherwise, and which DOT will not agree to maintaining it for a small amount of site, which we know from many of the private roads that are being built. What DCAS will insist on is some kind of like a deed agreement or something like that. And I think it requires a greater discussion both with DOT and DCAS jointly and separately. And I would recommend that when the applicant is having this discussion, that somebody from BSA staff is also at this meeting to further explain the elements of it.
Okay,
That
so,
would be my suggestion.
but we don't know any of this. This is guessing, because we don't know if, I mean, don't forget that the borough president wants to get these things properly handled. And so there's motivation to take care of these things in the proper way. So we don't know how any of these agencies will handle it. And without asking them specifically that we want to be able to use this part of a map street that's owned by the city to access a piece of property, which is what map streets are for, how do we do it? I mean, instead of entering in with a no, we should be entering in with a let's solve the problem.
I'm not saying that. I'm just saying that this is what I know from very recent, recent meaning 5 years ago of practice. And I think that's what DCAS's role is. So yes, we should go ahead with a positive attitude and see how it can work. But okay. I would say in that case, we just need to be mindful of the outcome. That's all.
Okay, thank you. Mr. Dale or Ms. Agnastu want to say anything further?
I'll speak. This is Todd again.
Yeah.
I would just say that, following up on what was just said and what was said at the review session, if I might suggest and see if the board agrees with this approach, is that it's a twofold approach. We could further examine the possibility of developing the site with only the GCL 35 waiver, concurrently providing a plan that would show access through lot 32, and do that in conjunction with reaching out to DCAS. The concern would be, it was mentioned that this has been going on for some time, the DP drainage issue, we understand this. I believe that this property owner has exhibited an interest in developing the site and to work with the various city agencies. If at some point, is it possible that the board would recognize, though, that DCAS is just not interested in providing this parcel, either via transfer or lease, or allowing the property owner to develop it at their own cost? At some point, we believe it should be fair to recognize that the property owner just might not have access, and we would need to proceed without that access. It's not fair to just keep spinning this off and off and off if we're never getting a response from DCAS, because, quite frankly, as a private property owner, you are less likely to get a response from DCAS than a city agency.
No, absolutely understood. But I would say that I think the general thinking is that this site is reasonably, let's say, reasonably open to a GCL 35 waiver, but not a 36. So if the drawings, if we went by the drawings that are currently shown as the as-of-right, then that's what you would have. If you have another set of as-of-right drawings where access is only from Clintonville, then provide those, because those will become the approved plans for the GCL 35. And then alternate, you could do an alternate. You could say if we're approved to access from lot 32, the layout will be this. And if we're approved to access only from Clintonville, it'll look like this. And that way, at the very last minute, we could decide on which one, or even be creative about how we vote and say, conditioned on DCAS and DOT working something out together on access through lot 32, then plan B, otherwise plan A, something like that. I think that would be a more efficient way to go than waiting to hear from before you make any moves.
Okay, I mean, I will defer to Sandy and the team as far as the plans they can develop, but I just wanted to lay out that process. The one thing I would want to just note, though, is during review session, there were comments made about this site in comparison to Nello. I just want to supplement anything that was in the submission that this lot is a different situation than Nello, whereas Nello Court, the lots that were there, the original tax lots were there, just went to the center line or into an even line of a block. As was pointed out in the submission and the land use study and everything that was done here, these two lots, I think it's lot 21 and lot 20, they are longer than any other lots in this block. And there's a significant portion of this property, both the interior landlocked parcel, but also the longer lot 20 and 21, that extend to a length that's much greater than the lots to the north that are developed with residential lots. So there is a practical difficulty, and I realize that we're going to explore the general city law 35, but we would still maintain that there's practical difficulty in accessing a significant portion of these parcels because they are out of character with the other parcels within the subject block. And I think that's important to note. And I just wanted to clarify that this is a different situation than Nello with an even rear lot line.
Okay. My response to that is the practical difficulty isn't in the access, which is what this is about. The argument is that your proposal is these long, narrow buildings, which you're not obliged to build. And the land use study shows many, many sites that are not built to their full FAR. Plus, you can do offset structures. You don't have to do structures that are, you could use flag lots. There's lots of different ways of going and still maintaining frontage. This is just kind of the most, for lack of a better word, sort of the dumbest layout where they're all running parallel to each other, but you don't need to have a lot configuration that's like that and take good advantage of the site. So I don't see that the amount of floor area that you might naturally build here is out of character with the neighborhood, because we do see some pretty big houses in the neighborhood, right? So on Clintonville, there are houses. There are houses that are like 3,000 square foot on a 6,000 square foot lot, 2,700 square feet on an 8,600 square foot lot. I mean, there's one that's 9,800 square foot lot with a 3,700 square foot house. So all of those houses that are just on that one little list are significantly underdeveloped for the zoning district. There's no reason you don't need to have your full floor area to be, that's not a entitlement. Okay. Anything else from anybody? Okay.
Well, I'd like to add something. Hello?
Okay. Yeah, go ahead.
Yeah. So the owner did reach out to DCAS again recently, sent a letter to Kyle Daniels from DCAS on April 2nd, and I can forward that letter to the board and received no response on that.
Okay.
There are some lots in the area which actually have two homes on them, lots 13 and 14, lots 11, 111, 8, and 9, and they're actually two homes on those lots.
Okay.
So we do, I understand what you're saying about not using the full floor area, but these two lots in particular are extremely long and extremely out of character. They're the only two lots that are this long in the entire block. And some of the longer lots, which I pointed out, have two homes on them, like back to back.
But yeah, so, but again, there isn't a requirement that you use all your floor area. There's also not a requirement that you lay your lots out as these long and narrow lots. You can lay them out differently. So you're opting to lay them out this way. You could also create flag lots where the houses are situated in a way to shorten the apparent depth of the lot.
Well, we laid it out this way just to front on Clintonville Street, provide so that they all front on Clintonville Street.
But you could bend them, you could shape them differently. But the point is also, you have 4 houses and the request is 5. So that part's very similar to Nello in that you can already develop the site. It's not like you can't develop the site. So anyway, I think we've already had this discussion, so I think we should move on to the next hearing. So so in terms of submission, what we should be seeing is a GCL 35 waiver request, where you've got frontage only from Clintonville and the houses are laid out the way you would want to lay them out, because that's ultimately what, of course, DOB relies on. And another version where you're accessing from both Clintonville and 150th down 16th Road, improved as a city street. And then we'll figure out in the interim how that might work. But at least we'll have both options going. So okay. Any questions on that?
Yes, I understand that. Okay.
Great, thank you. And so you should continue. Yes, please do submit the letter. I don't know who Kyle Daniels is or what department. So, and we will reach out ourselves, but you should continue to try from your end as well. Okay.
We will.
Thank you. Thank you for calling in. Oh, and also we looking for any testimony from the public, which I don't think I've been asking for. So if there's a testimony from the public, please call in 646-558-8656. And this is Clintonville Court, Queens, 2018-105A and
2017-1619A.
Okay, thank you. Give them a few more seconds, and otherwise we move on to the next one. Thank you very much for calling in, Sandy.
Thank you. Thank you.
Okay, next one.
2018-201A,
46 Kissel Avenue, Staten Island, and Todd is the applicant.
Good afternoon. Yes, you don't have to wait for anybody to log in this time. So we did listen to the review session and the comments that were made. Just a couple of things. I know we're waiting on the fire department letter. If there are any issues, we'll be able to respond to them quickly. Inspector Daly, if he's listening to, can also, copy our office directly on the letter, maybe to expedite any response. I believe we're waiting on the DEP approval also. I would just note that we do have the site connection proposal. We did submit the approved site connection, so hopefully that would satisfy any DEP questions, but if there's any subsequent letter, we'll respond to those. There's a question regarding the parking. Just to clarify, if these were both new buildings, there would be 6 total parking spaces required for the zoning lot. However, the existing building is a pre-existing non-compliant with the 2 parking spaces. So the total zoning lot only needs 5 total accessory parking spaces, 3 for the new building and 2 for the existing building. And there are 5 that are proposed. I'll reach out to the architect though and see if we can get a little cleaner clarification on where those parking spaces are. But just to note, 5 spaces total are required and 5 would be provided.
Okay, there's no mention on the drawings that do have zoning information. There's no mention of parking, so that needs to be added to the
That's fine. I'll make a note of that right now. That we'll clarify the parking, but I just wanted to speak at hearing that it's 5, not 6 that would be required for this total zoning law. And then, the last comment, I know that we did try and, we broke into our library and tried to submit as many historical maps of this area as we could, going way back. I was just going to point out that the Linen tax map, the reason that we noted in the letter that it was, circa 1960 and 1970 is I'm not sure how familiar everyone on the board might be with these Linen tax maps, but prior to the digital implementation of the maps where every time there's a change, they'll issue a new digital map and they'll upload the PDF to the site. These Linen tax maps were mostly started between 1960 and 70. There's no exact specific date. I've reached out to finance to see if they could give one. But what would happen is they would have these maps and these books, and anytime a change would happen, they would just hand write in the year and the date of the change. So we reference 1960-70 as far as that being the estimated time as far as when the Linen tax map was first created, but then they were kept as sort of a living document for 30 years until they digitized everything.
Right.
So between the Linen tax map and the historical Sanborn and other atlas maps we could find, the estimate we put forth is that the flag lot was finalized sometime between 1936 and 1960. Unfortunately, without any other specific map, we can't find it. And at this point, with the current public health situation, we really can't dig into like the title book records to find out, but we would feel confident that this information shows that this lot has existed prior to December 1961. I would also note that we reviewed and there is no zoning lot development agreement with any of these exterior lots. So there's no requirement that this lot is providing open space or any zoning ties to any of these other surrounding lots. So I just wanted to provide the history for this lot as best we could, that it's been this way for at least 60 some odd years with no development restrictions. And it's also, there's another flag lot on the block immediately to the south that's very similar to this.
Yeah. So, okay. So the map that you describe as the Linen map, doesn't actually have any dates next to the updates. Usually it'll say, well, it does. It says 1975 or something that lot 50 was whatever they did with lot 50, right?
Yeah, they totally adjusted it.
Yeah. So what you're saying that if the Linen tax map was drawn prior to 1975 or whatever the earliest date is that I can't see on this. In other words, that lot 78 existed because that's the original before it starts getting amended with notations. Is that kind of what you're saying? That
correct. So just to provide so what would happen is, because we do this a lot, we're very interested in speaking with the finance about this. These maps, I was told, were initially created mostly, as I said, circa 1960 to 1970. And generally, they will have the dates of when a change is made. On some of the Linen maps, for some of the blocks, you'll see a date that says like 1960. This one appears to have a date of 2005. There's a 1978, there's a 1973. I don't know if there's one older than 1973, but like affirmatively, we can say that lot 78 as it existed as a flag lot was at least in place at 1973, if not earlier. I was flipping through the map quickly to see if I could find any other notations, but I think 1973 might be the newest one. Well, there's 1974.
the oldest one.
Yeah, the oldest one, I'm sorry.
Yeah.
I spoke.
Right.
So 1974. So, I would say that based on this and based on the historical maps we provided, it appears that this lot was originally created, this structure, sometime around 1936, because I think that Sanborn map starts to show the flag lot in 1936. And that's
the part I'm not seeing. Where do you get that from? We have 1934 map, right? You provided these two maps that shows Eleanor Walser was the owner, and then the house that Eleanor owned and the little back building are still there on the subsequent map, which is the last of the old maps. So I don't see where the flag you're talking about seems to be. Maybe I'm
Well,
missing.
so in the Sanborn map, which is 1934, you start to see the structure of how they started to separate. Unfortunately, that Sanborn map, where our actual lot is missing on the map, but you can start to see where they started to develop the homes at front on Delafield Place to the north and Amelia Court to the south. So you are correct. There is a bit of an assumption there because we don't have that very specific. These Sanborn maps, because they were used for, insurance purposes, weren't required necessarily to show every single portion of a block, but that is where the site would be located. So you're correct. I don't have a specific map in all of our research and our atlases that have a specific date as to when this lot came, but upon all the available information, it was created sometime between 1936 and we would say 1960-ish, which would predate the zoning resolution. But I would say most importantly is that we went through and there are no zoning lot declarations on record, because I think one of the concerns about this with this lot was, is this space tied to any of these other development parcels, I believe, and it's not based on the information that's on record.
And this is the part I can't remember from your application. Did you do a deed search on lot 21, which is your lot?
I believe we did. I'm not sure. I mean, because you normally do that for an undersized lot, since this is not an undersized parcel.
Because you still have open issues, maybe if it's, I don't know whether it's possible under access in Staten Island, because it's such a strangely recorded place, to find an early deed for lot 21. Which would then,
what we can do is I can speak to the property owner and see if he has a title report from his title insurance company, see what's there. Unfortunately, there is limited access to public records during our current circumstances. You can't really go in and look past anything that might not be available online, but I will see, in short, we will see if we can supplement the information.
okay.
But we provided everything we could just to say that this particular lot, which is reflected in the block below, has been in existence, for at least 50, 60 years.
Right. Okay. So that's the thing. It's like I'm missing a little bit of a link that you're making. But anyway, I'm basically persuaded that this is this bizarre anomaly in the middle of the block. I don't understand why. But I think we still had issues here, right? So
Two agency letters. So while we wait for the agency letters, we can supplement the research we provided, and we will also reach out to the architect to see if we can get a little bit more clarity with respect to the parking.
Okay, great. Anybody?
My only question about the agency letters is, I would trust the fire department. They tend to be very quick about a response. If, when this is scheduled for a future hearing, if we still have not received a DEP response, I would just ask that the board could be persuaded by the site connection proposal, the approved one that we provided.
Okay, well,
Let's just say that the short of it is sometimes DEP letters take a little bit longer, and we wouldn't want, if that was the last outstanding issue, to continue to push this off if everything else is satisfied.
Okay. Okay, so the DEP is Tracy, where's Tracy? Angela.
It's Jella's project.
Yeah, hold on a second. I can't.
Hello, hi. I just wanted to verify that I sent DEP all of the items in the submission on April 2nd. So it's been there for a few weeks, but and I did send a follow-up email, so hopefully that might speed them along, but just to verify, they do have the materials.
Okay, all right, great.
Okay.
Great, thank you. All right then, so if there are speakers on this item, please dial in. This is 2018-201A, 46 Kissel Avenue in Staten Island. Kurt, can you show the screen that shows the dial-in number? Thanks. So you would dial in to 646-558-8656. And the meeting ID is 469-050-895, and that's on your screen. Okay, so how much time do we think I see Shampa's, Commissioner Shanda's hand as, how much time do we think we need for DEP review? I'm unmuting Jella. There we go.
They didn't give me an estimated time frame, and this is a different division of DEP. It's not like the seeker division that does a normal 20, business day turnaround. They have their own schedule. I'm not really sure, but I can ask them what. Oh, it's too late now, but they've had it for a little bit.
Okay. Well, because we don't assign the dates at the hearing anyway.
Oh, okay.
You could send a
Okay.
request. We'll find out. Okay. I'm muting you because of friends, right? And Commissioner Shanda?
Yeah, you know what, while we were discussing this, I was comparing the 1936 Sanborn map with the Zola map, just to kind of see some of these building orientations and the date of the buildings. And maybe you can use that, Mr. Dale, to kind of roughly orient. I think the 1936, where you're locating the arrow and all, that is correct. And maybe you can take that, work backwards from that, because it really fits in the Zola map and the 1936.
Thank you. We'll take a look.
And there are historic alteration books online as well.
We did look through those alteration books, and unfortunately for this particular block, I've got time during quarantine, so I ran through all the different alteration books, and this block and lot were not listed in any of those alteration books, which further complicated the whole.
Which one? So this is block 78, lot 21, is that right?
Yeah, so I went through and I looked through the block and tried to find anything, because I don't necessarily, when I look at the alteration books, I don't look at the specific lots because lot numbers change. I try and focus on the block number. And I went through looking at block 78 and I didn't see any, referencing this particular lot number. We can take a look again, but.
Because I'm looking at one from 1970 with an entry dated October 2nd that has to do with lots 21 and 29.
Okay, I'll take a look at that one.
Oh. It's 29. Oh, that makes sense. Oh, that one is actually noted on the drawing on the linen map. It looks like lot 29 sort of purchased or something, little piece of lot 21, and sort of projects into it by a few feet. But that's actually noted on the linen map that Todd gave us.
Yes. Okay. Yeah, that situation is where they adjusted the rear lot boundary of that. Yes.
Yeah, it doesn't say the date though, but obviously it's after the creation of this map initially.
Right, and that wouldn't affect like the bulk of the lot, and its primary configuration is like an interior lot with a flag.
It's just cutting out a little nose out of it. Yeah.
Mm-hmm.
A very strange one, by the way, but yeah. Okay.
Probably for a rear yard.
Right. Oh, that could be. Yeah. Okay. All right. Thank you very much. I think we gave time for people to call in and no one did. So thank you very much, and on to the next.
Item number 4, 2019-195A, 191 Industrial Loop, Staten Island. Again, this is applicants as Roth Group. Mr. Dale.
Good afternoon, Todd Dale again for the applicant. From review session, there were a few questions raised. First of all, agency letters again, the fire department and the DEP. If we receive the letters, we'll try and respond as quickly as we can.
Sent them out.
But it's our belief that this plan and survey show the items typically requested by the fire department for these applications. And with respect to DEP, there is the sewer that runs through private industrial loop, and that's the connection. But if there are any questions in those letters, we'll respond in kind.
Mhm.
Then there's a question with respect to the builder's pavement plan. And I think some of this may be a terminology issue sometimes when we communicate it to the architects. First and foremost, I would say that the site plan as presented does show the fact that we are proposing a curb cut and a sidewalk on the front of this particular lot. For other applications our office has provided, that's generally what we've shown as a continuation of the sidewalk. With the builder's pavement plan and providing the waiver and improvements, which is given to us by the architect, described to me, the builder's pavement plan would only be reviewed by DOP, would be reviewed by DOP for a city map street. And since this is not a city map street, there would no actual builder's pavement plan required to be presented or reviewed. Now, there could be a roadway improvement plan or a theoretical builder's pavement plan, but I think that some of the communication we have with architects is when we tell them about a BPP, they're like, not required because it's not a public street. So we can, if the board would like to see it, it is shown on the site plan, but if you want to see a blow up of that front of what we're proposing with the sidewalk, we can provide a supplemental frontage plan for the roadway improvement. We're happy to provide that.
Okay.
Okay.
So, however you want to call it, we just want to make sure that it's got all the same notes as you would have on a builder's pavement plan to show that.
So we'll call them, we're going to call it a roadway improvement plan, and we'll give it to them. Okay. So we can reach out to the architect and get that for the front of that site. And then I believe it was Mr. Chanda had asked a question about parking and loading berths. Just to clarify, and I believe this is consistent with the plan and the zoning analysis, there is 0 accessory parking spaces required because they're waived due to the expected number of employees, and there's 1 loading berth that's required. However, they are providing that 1 loading berth and providing 10 accessory spaces that are optional. So it's 10 provided, even though 0 required. And I think that when I reread the most recent statement, which I believe it is, we clarified what's required, but we didn't say in the statement that 10 were being proposed, but 10 are being proposed, even though 0 are required.
Great, thank you. That's it on this one. Okay, great.
Just Madam Chair, so John emailed me, they're meeting with Captain Deloitte. He's meeting with Captain Malloy tomorrow to discuss industrial loop.
Okay,
So-
that was John Daly.
John Daly Fire Department.
Okay, and I'm unmuting Commissioner Shanda. Oops.
Sorry.
So I think this is where I'm a little confused because the statement of fact says 0 accessory parking spaces are required and 4 spaces are normally required.
What?
Yeah, it says 0 accessory parking spaces are required pursuant to 44-21 and 44-23. And as 4 spaces are normally required, 1 per 3 employee, 2 employee total, are waived as they are less than 15 permitted to be waived under ZR 4423. Okay.
So they're waived, right?
Okay. All right. Okay.
It's rated occupancy or
Right.
whatever.
Right. Okay. Got it. Okay.
Okay.
Okay. I read it so many times and yet it just went over my head.
No.
This is what working from home does.
Okay.
Okay. All right. I get it. No. No, I get it. Okay.
Okay.
Sorry.
Okay.
And Commissioner Sheta also had his hand up just a second. Okay.
I did read the same, and I understood it as since they are less than 15, they're gonna be waived by the DOB, but they are not waived by us. Is that what it means?
No. So this is only a GCL waiver, right?
Oh,
So
okay.
we're just looking at whether they're on a map street or not, whether it's okay, right? So we're just making sure that when we review the drawings, we always try to make sure that it's complying with the zoning regulations. And
Yeah.
when we see something we don't understand, or where we think it doesn't comply, we ask the question. So in this case, if you did the math based on occupancy, you require 4 spaces, but then it's fewer than the 15, and so you get to waive those spaces.
But are they waived by us or they?
No,
zone.
waived as of right by the zoning resolution.
Oh, okay, okay.
So on these GCLs, we never waive the zoning, right? Unless
Mhm.
a bed of a map street, in which case we end up waiving setback requirements,
Okay,
right? Because they can't set back far enough from the street line.
I got it.
Okay,
Thank you.
okay. Todd, did you want to add something?
No, just to confirm that regardless of the math, we're providing 10 accessory spaces, which the community board was very happy about.
Okay. And the whole purpose of this site is basically a loading berth, right?
Yeah, there's going to be like individual warehouse units with a tenant to be determined, and they just wanted to provide the parking spaces above and beyond what was required.
Right, okay, great. All right then, so really the only thing is this roadway improvement plan and waiting for fire department and DEP to get back to us, right?
Agreed.
Okay,
And just for timing for our office, we'll be able to get that improvement plan very quickly. I realize you're going to assign dates in the future, but just to let you know.
okay, thank you. All right, and now to ask if there's anyone from the public who would like to speak on this item. This is case number 2019-195A, 191 Industrial Loop in Staten Island. The dial-in number is 646-558-8656, meeting ID 469-050-895. Give it a 30 seconds. Okay, thank you very much, Mr. Dale, for dialing in.
Thank you. Have a good afternoon.
You too. Tony, go ahead. Are you muted? Oh, you're muted. Why are you muted?
I don't
Sorry.
know why. I'm on now. Sorry. I had muted myself because I was getting a phone call on the city cell. I thought it was important.
Okay,
Zoning calendar, item number 25, 2019 6BZ, 138 East 39th Street, Manhattan. The applicant is Frederick A. Becker.
mhm.
Please call in. Fred.
So now all of our notice of hearings are going to require a phone number from the applicant so that we can call the applicant and say, you need to dial in now. So we don't do this. And arguably, like we had that problem before, we could speak to that person using a speakerphone if we had to. There we go. Nope. All right. Please state your name.
Frederick A. Becker, to be sworn in.
Hi.
Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Thank you. Proceed.
Frederick A. Becker.
Okay, go ahead. Turn off your video, Fred.
Yeah. Can I speak? Is
Yes,
the chair done?
yeah.
Okay. All right. Frederick A. Becker. Good afternoon, Madam Chair, Commissioners. I listened to the review session, and there are a few issues that come up that seem not to be getting covered correctly. In terms of a new building, this has been deemed can still remain as an alteration according to the expediter. So that's why, even though we refer to it as a new building, it really is a renovated building. I was trying to clarify that, as opposed to existing proposed, effectively it is a entirely proposed building, but it does still stay as an alt 2.
No, an alt 1. It's an alt 1.
I mean, I mean, but it's not an NB application.
Correct. It's an alt one, not an NB.
Right, it's an alt one, I apologize. Yes, an alt one, not an NB, which is what we have it as.
Okay.
So in terms of the second floor, first floor issue, if one looks at the plans of the first floor plan, which has the waiting area, reception area, offices, et cetera, versus page P04, which is the multi-purpose reception, not reception, the multi-purpose function room, there is, if we were to flip the floors, there is not adequate space on the front of the building to properly have a entrance, reception area, security area, et cetera, which prohibits the flipping of the floor. And that is, it is purely and extremely a security and functionality issue. There needs to be an area which is provided on the first floor where there is an entrance area, there's a waiting area and reception area, there's a coat room, there are bathroom facilities, which then allow people to safely and securely go to the upper floors. We cannot flip the building, that space, which is the Archbishop's study on the second floor where the multi-purpose room is not an adequate area to do anything. And if you start shifting the stairs and the elevator backwards, it defeats the whole purpose of the building.
Well,
So
that's what you say. That's not what I see, but all right.
that is what I mean, we've discussed this. We understand the board's concerns, et cetera, but this truly is why we cannot flip the building. It's been, believe me, it has been looked at. If we could flip the building, we wouldn't be here, and we can't flip the building. And this is why we are here again and again and again.
Commissioner Otley Brown had her hand up.
Yeah, I think probably your argument would be a better argument if you put the measurements of all the different segments on the first floor as well as the second floor, so that you could show us what kind of room is taken up by the multi-purpose room or ceremonial room that would go further than the current first floor work area, storage, bathrooms, and offices. And also, I'm not sure why the Archbishop's study would need to remain on the same floor as the ceremonial room. Why couldn't that stay on the second floor where it's currently proposed to be? And you would leave the bookstore and the waiting area on the first floor, and then just have the ceremonial room take over that whole rear portion. So I would say that if you could dimension all of those little line segments, you might prove your case a little better. Because right now it looks to me like you could swap that back work area, office area for the ceremonial room, leave the bookstore and the waiting area on the first floor where they are, and leave the Archbishop's study and those bathrooms and the kitchen on the second floor where they are.
Okay, I will look into that. I'm seeing, for what it's worth, just immediately, that the reception area is 925 square feet, and you have the director's office work area, office storage really comes down to less than that. Not significantly less, but enough less that it does make a difference.
Hmm.
And also
because
Yep.
I see on the first floor, and I could be looking in the wrong plans, the waiting area and reception is 200 square feet. Where's the 900?
Well, the 900 is on page P04, which is the ceremonial room.
Oh, you mean the ceremonial room is 900 square feet, and you wouldn't be able to fit the 900 square feet on the first
Right.
floor.
Also, if you start adding up the coat room, the waiting area, the bookstore, and the area that sort of goes from the entrance to the stairwell approximately, you're talking about an area of more than 500 square feet, and that area cannot be recaptured on the same floor as the ceremonial room. Even getting rid of the Archbishop's office.
Is what I'm saying. Why couldn't you just, because if I'm looking here at the first floor, adding up the square footage of all those rooms, the work area is 400, the director's office is 200, so that's 600. And then you've got 3 offices at 90 each, that's another 270. That's 870
Right.
square feet right there. Why couldn't that be the ceremonial room? And then leave the waiting area and the reception area where it is and the bookstore where it is.
You don't have, there's some space for the kitchen on the floor, which is essential to the new use of that. There's some storage for chairs, et cetera, et cetera. There is some open space. I'm not quite sure what that is being used at. This has been the traditional use of the building for all these years, where the Archbishop or His Holiness, the prelate himself, comes off of this space directly into the other space. It's a ceremonial type of function. It's a practical function. I understand what you're saying if you flip space and space, but it is preferable from, again, I can go back to the security argument. I have gone over this with the prelacy many times, and they feel that it is not safe to have that space on the ground floor and on the same floor where people are coming in. I'm just telling you what I've been told.
Can you explain that? I don't understand. So when people are coming in, if I understand this correctly, the ceremonial space is for the public. So you've got the public coming in and going up the staircase and going into the elevator. And now they have like free reign of the building if they're in either of those two things. So it seems to me that the security is actually really compromised. And if you also look at the layout, if you also look at the layout of the first floor without adding up each 98 square feet and all that stuff, the edge of the 2 bathrooms on the first floor is the same line as the edge of the storage room on the second floor. So it's just exactly the same layout. So I don't actually understand the argument that the space isn't big enough, because with the exception that you don't have the Archbishop's office on the same floor as everybody else, but you could maintain, like Commissioner Brown said, the bookstore stays there. You already have the waiting room, you have a coat room, you have 2 bathrooms, and do you get rid of maybe 1 bathroom to have a kitchen, or do you put the kitchen downstairs in the cellar? Those are the kinds of things, like, why not? And I really don't get the idea that you want the public wandering around inside of your building when the best security is having it at the ground floor, where people come in and then you throw them right out.
The staircase is not accessible. There will always be security there. There's a door in front of the staircase. So that it's not open for people to wander around. It's a door that's locked except for security, a push bar on the inside, an emergency exit, so that people cannot go up the staircase and wander through the building. They have to come into the reception area, the waiting area, and then be vetted, met, discussed, and then sent out to various parts of the building.
No, but in order to go to the ceremonial room, you need a conveyance that gets you vertically into the building. The conveyance is either the staircase or the elevator. And frankly,
correct.
Right? So once I'm in the staircase on the second floor, arguably, let's just say I took the elevator up. Now I want to get out, right? Now I'm in the staircase and I can wander around in the stairs and go, I have free reign of going up and down the stairs.
But they can't get to the elevator and they can't get into the staircase until they go through the waiting area, reception area, and or security before they get into either of those 2 places. The prelacy is not concerned with people wandering around the rest of the building. Once it's getting them into the building, keeping them separate from the rest of the building. And this way there is a barrier for them to not go for basically, once they get past the entrance on the first floor, and if they somehow run into reception area, a waiting area, then they can just theoretically run down into the what would be the multi-purpose room, and that is not deemed a safe condition by the prelacy. This way they have to at least go up a level one way or the other after being vetted, and then it's considered a safe condition. Otherwise, they can just theoretically run down the hall into the multi-purpose room, and that's not a desirable situation. They have never had it that way. They don't want it this way. They don't consider it a safe condition. That's the bottom line.
Sort of makes no sense, but okay. Sorry, makes no sense.
I understand.
We deal with synagogues and churches and other kinds of religious institutions for, every day. You enter the building and you walk right into the prayer space directly from the street, and the least convenient of them make you take some kind of an elevator or stair to go up to another level for those prayer spaces. So yeah, that just doesn't really make any sense. But okay, I don't want to belabor this.
But there was also the issue, and I know that we've talked about a modified building, given the length of time this has gone on, not due to the board and any fault whatsoever. But given now the current situation economically, there is a very strong chance that the building will be used as is. And if that is the case, then we go back to the issue of the space being inadequate in height on the ground level.
Okay. All right.
I mean, this is a variance that was granted once before. It fits, as everyone keeps saying, it's minor, 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 and it fits, it dovetails into two adjacent structures and is no higher than those structures. I mean, I can't emphasize more. We gave some arguments. I tried to clean up the papers in terms of encroachment, enlargement, existing, proposed, all of the above. This is what the prelacy is fighting for and believes is the way they need to operate their building. I can't go beyond that. It's their programmatic need, and it's not my calling. It's their calling.
Right. No, I understand it's their programmatic need. I wish that it was better explained because there's an enormous amount of conflicting information in the application. And each time we read it, there's a new piece of conflicting information. And so all we're doing is reading what you give us. And you have your executive director says one thing and your statement of fact says another thing. The drawings say another thing. So to say that it's clear to the prelacy, it's not clear to us because the papers aren't clear and you need to be more careful in your papers. I'm going to recognize Commissioner Shanda, who has her hand up.
Yeah, I was just doing a very quick back of the envelope calculation of the second floor without the 30-foot setback that is being requested. And I think what is left over of the space comes to about 720 square feet, roughly, give or take. And whereas on the ground floor, the office space that's in the back, which has a separate door entrance separating from the waiting area and the courtroom, based on the room sizes that's given, that's about 870. So I just did that calculation just to see can those program spaces be accommodated on the second floor without the 30-foot setback. And,
well, but yeah. I'm sorry.
And I'm saying, based just on the number, 720 versus 870, it won't. That's just what I'm saying.
Right.
But that's for you to.
It won't work out.
To
Right.
the top floor. You could add a floor.
Adding the floor doesn't work with the uses in the building, just shifting it. The idea is to have this room, which is so large, which is the existing portion plus the enlarged portion, That's the whole issue. This goes back to the very beginning. It's not a matter of relocating things. It's a matter of having a room that's this big in the location, separate from an entrance, a reception, a security area, a coat room, et cetera, which makes for the proper functioning of this building. This
No.
building,
You're missing Commissioner Otley Brown's point. The question, and again, I don't really want to beat this dead horse. We just wish that you were clearer in your submission, because the reason this has gone on and on and on is every time we see something, the information is different and inconsistent, internally inconsistent. But we're not talking about saying you couldn't have your large space. The question is, can you put the large space on the first floor? Then you don't need the rear yard waiver, because you can get 700 and however many square feet of office space on the second floor and make up the difference by, you're already adding a floor here, and make up the difference by adding an additional whatever it is to get you that additional office space.
right.
In other words,
And the answer is has been looked at. It didn't come blindly to this application. There was history which brought them back to this application from the prior grant, and the issue of relocating, splitting up the office space here and there, adding another middle floor for the office space, adding another floor on top is not it was not deemed appropriate for the programmatic needs of the building to be used in this regard, and to split up the uses in that, the way is being suggested. And that given the nominal level of the increase, the minimal variance, which is now down to just the one space in the rear, not the two spaces, not floor area, we reduced the scope. This is where it was felt that was most appropriate. And I mean, I believe the plans and the statement clearly are in sync in terms of what use is on each floor and how things are used. I can go through that one more time, but the split it's a justified split, and we go back to the way the building operates, in which the building has operated and is found to be the most appropriate way to operate.
okay, Commissioner Otley Brown, yeah.
I
Okay.
recognize that this is a small ask. And because it's a small ask, I'm going to let the argument go. But I have to say that if this was a larger waiver request, it was not very clearly discussed as to why, not only that you need the space where each use is, but why the uses must be co-located in the way that they are co-located. So I would say in the future, if you're going to have another variance, it's going to be, and it's not going to be enough to just say the congregation wants this here because they want it here. They're going to have further discussion in more detail as to why certain things can't be located together, or why other things must be located together. And that would really close up your argument, but I'm willing to just let it go here and
Right.
not put it in.
I appreciate that very much. I'm willing to, restate that in a statement, and even if the board is willing to even close this today, leave the record open, I'd be willing to make those statements that will further explain it so that it is in the record. And I appreciate letting it go, but I'm also happy to set it forth in much more detail, which
Okay.
for a better record.
It's not just, I just need to add, it's not only in more detail, it's more that you're not focusing on the questions, and then the materials you give us are internally inconsistent. So you need to actually read the materials and make sure that when you get something from your client, it agrees with the thing that you just said, and so that's one of the reasons for the frustration on the part of this board, that we keep reading it, hoping this very simple application will just simply state why the organization needs what it needs and where it needs it, and then we don't see it. So this is for going forward. I don't want to read another submission where we're trying to find the answer. I think we're all done with this, but I'm just trying to persuade you to please be a better applicant and more careful with your submissions. And when you submit things, don't just submit them the second you receive them from your consultant or your client. Read it and make sure it's consistent throughout and it tells a clear story about the request and the support for the request. So are there any other comments from commissioners? Yeah.
There were,
Shonda? Hold on a second.
Comment, and that is with regards to PO8 and all the elevations and the sections. If we are to grant the rear yard waiver, encroachment waiver, I think the drawings very clearly should indicate the actual elevation height. The elevations and the section indicate the total building height, which is also shown as plus or minus, but the third level where the encroachment is being permitted, especially in this section, it should be clearly labeled what that height will be in the rear.
The height.
okay, so in other,
PO9, if you go to PO9 specifically, which is the side elevation, and P10, I think for, since these drawings, if we approve these drawings are going to go to BSA, to DOB, we should clearly have the actual height.
right,
of
I
the
understand. So in other words, rather than being between the 11 feet for the second to third and 10 feet to the third to the fourth, it should be third level, let's say, I'm picking a number, 24 feet.
Right,
Something
you can
like that,
maintain
or-
this 10, 11, whatever, but the
No,
third
I understand
level,
that. You're saying
you should have
add,
clearly
right, add,
labeled that.
right, add the additional number, i.e., I'm saying, i.e., 24 feet or whatever number that
Yes.
is. I'm just picking an approximate number, eyeballing it at this point.
Well, but in addition to that, you've got a measurement that is only on the street line. You don't have a measurement that refers to the height of the addition in the rear. That, I think that's what.
I think, well,
Right, that's what I'm referring to.
if I'm not mistaken, doesn't it showing on PO8, it shows that the floor of the second level, of the third level, is at a 21-foot height. I'm just want to make sure that I'm not missing something here.
Well, it actually only
Because-
shows it's at 10 and 11, right? It
So
doesn't.
that would be,
It doesn't show that where the roof is, right? It's 10 plus 11 to a non-designated spot, right? You don't know that that's the roof of that extension, right? You just don't know. And that drawing on PO8. So, and then when you go
Okay.
to PO9, ditto, we don't know the height of the extension because there's no dimension line that tells us the height of the extension. And when you go to P10, it's 10 plus 11 takes you to the top of the third floor. And then you can interpolate that that is the height of the extension at the rear, right?
And that does not add up because if you look at the elevation, the ground elevation in the rear, there's a line drawn. I'm assuming that's the elevation in the rear, and that wouldn't be then 10 plus 11. It would be different. So, so use the front elevation and then just indicate what that height is.
Yeah, you don't measure
Okay.
off of rear grade anyway.
Right.
You
Right,
measure
you
Right,
off
don't.
so-
But if one looks at the back elevation, the proposed rear elevation, it just looks a little confusing.
Yeah, you need to be clear that that elevation at the rear is 21 feet above curb. That's all.
Fine, okay, fine. That's easy enough done. I also heard the comments, I see on drawing PO3, I think it was, or the third floor elevation, it needs to be shaded. The third floor plan, which I think is PO5, needs to be shaded similar to the other ones. I don't know how that, I didn't pick up on that one. So you said the third floors were not rendered the same, which I picked up as not shaded. The 24 and the zoning calculation sheet on P01, it should be 23 feet, not 30 feet. He mixed up, I mixed it, and he mixed up the rear yard depth versus the height. And I see that on POO, we need to put the the zoning district.
Yes. Okay. Okay, good. All right, then. Are there any?
So
speak-
basically, excuse me, I'm sorry to interrupt. So right now I'm just submitting new plans that nothing is, you don't want
Correct.
another
We can't.
statement. Got
do
it.
More things.
I understand that.
Okay.
Okay.
Okay, so if there are any speakers on this, 646-558-8656 is the dial-in number. This is,
2019 6BZ, 138 East 39th Street, Manhattan.
and the meeting ID number is 469-050-895. Give that a few seconds.
Sorry, I didn't interrupt.
So to make changes to the drawings, how much time, Mr. Becker?
In an ideal situation, I would say a week to 2 weeks maximum.
Well, let's not do, well, I don't know how your architect is working.
He's
What-
doing remotely.
Yeah, what's the reality situation as opposed to the ideal?
I think we can certainly, today is the 20th. I'd say we can get it in by the first week of May, easily.
Okay, okay. All right, then. Thank you very much. No callers.
Thank you, and again, apologies for further confusion. I thought I
Okay.
had done it, but obviously not. Okay, thank you. Stay
Try
safe,
to
everybody.
eliminate the word "I'm sorry" from your applications and just take better care.
I will, absolutely. Thank you.
So are we continuing this or closing?
No, we're going to take a 10-minute break because it's 4:30, so we're a half an hour more than we should be doing in a row. Oh, good point. We could close this. Yes, everyone okay with closing this? Yes? Okay,
Yes.
thank you. So I would like to make a motion to close.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta. Aye? Okay.
And so we'll put this on.
Thank you very
for
much again.
decision as soon as possible, okay? Thank you.
So the only submission is plans.
Yes, correct. Oh, okay. So we are going to take a 10-minute break, so come back at 4:45. Thanks. And I see that Kurt put up a break. Hearing will resume shortly. There. Thank you very much. We're still live, Tony, so.
No, I know. Let's stop the video, my video.
There we go.
Hello.
Hello.
Are we resuming or
Say,
are we resuming? You're waiting for the other commissioner.
we're missing a couple.
It says we're still live. Is everyone okay with that?
Yeah. We're on break. I think we're not showing the video. I don't know.
It does say live on YouTube, so I think we are. Sure.
It says
Or maybe not.
Yeah,
No,
we are live. We are live.
we are live? Okay,
On video.
That's what I said.
okay. It's hard to know because there's a break sign on the screen. Need one more. Commissioner Shibeta has his hand up. Do you want to speak?
That was from before when I was advising everyone that we were live.
Ah, okay, thanks.
We'll put my hand down.
And we have Frank Angelino in the waiting room.
Do you want to take that screen off?
Let's wait until everyone's here. Show grid. Oh, I think all the commissioners are here. I didn't realize, right? Commissioner Shanda, come back onto your screen. She was here a second ago, right?
Yes.
Okay. Well, I think let's just get started and hopefully she'll come in by the time. So I'm going to admit Mr. Angelino, and there's another guest. I'm not sure who that is. Well, that might be the property owner.
Okay, so we are continuing the public hearing for April 20th, 2020 at 2 p.m. The next item is 2019 7BZ 3341 Country Club Road, the Bronx. Frank Angelino is the appellant.
Yeah.
Mr.
Yeah.
Angelino?
Yes.
Okay, I have to swear you in. Is there anyone else with you?
Timothy Judge, the environmentalist, should be joining the meeting.
He's just admitted now. And how about Paul Chester? Is he related to you?
He's related, but I think he's just viewing at this point. It's just myself and Tim Judge, the others are viewers.
Okay.
Okay, so can I swear you in? Do you
Mhm.
affirm
Yes,
to
please.
tell, I'm sorry. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Okay, please proceed.
Thank you. As I understand, the questions deal mainly with the remaining few issues in the environmental review. And Timothy Judge, who has been involved with the city agencies in that review, and as well as the other agencies involved, is ready to speak to the remaining issues.
Okay.
Please identify yourself for the record.
My name is Timothy Judge. I'm with Echo Assessment LLC. I'm the environmental consultant on this project.
Mhm. Okay, go ahead.
Thank you. The two outstanding issues that we're aware of are primarily with DEP. They had requested a phase 2, which we understand as the phase 2 seems to be for an abundance of caution. The phase 2 was approved. The safety plan was approved also by DEP, and we're now simply awaiting permission to finally go out and do the work. Laurel Environmental is the contractor for the testing. They'll do the soil borings and the vapor tests as requested. They've been out on site to mark out those locations. However, under the governor's protocols right now, going out to do that testing is not considered essential work. As soon as it is, that will be done. We know from the phase one that there was there's no fuel tanks on site. There was a very minor spill many years ago, and that was closed up by the DEC. And so we know of no contamination on site. We understand the idea of doing the monitoring and the testing, but we don't believe that there's any active sites nearby that would contribute to any particular contamination at that site.
Okay. Okay, we also have an open waterfront resiliency or consistency plan.
We have provided the flood elevation worksheet and a set of drawings which show the elevations of the flood against both the north elevation of the building where it meets the seawall and the bulkhead and the dock, the existing pier. And we gave two drawings, one that showed it from some distance back and then another that was closer so that you could actually see the differences between those flood elevations. I had requested and sent information about there were two paragraphs that we've revised, and if those haven't been delivered to the BSA, they will be forthwith.
Okay.
And part of that was about the resiliency of the deck. And we had addressed that in testimony previously. The main thing is that the deck will be proud of the pilings, and the pilings themselves are cut so there is essentially a tongue coming out of the top of the piling, and then boards are sistered on either side of that. The joists that run across for the decking will be sistered to the piling itself, and because we're going to be using a marine grade Trex, you have to secure those 12 inches on center rather than 16 on center because of deflection of the board themselves. And so it gives more fastening points for the deck of the pier itself. Also, every 10th board will be a grate, and the spacing between the boards will have a 1/2 inch spacing. One of the nice things about the Trex is that it does not expand when it gets wet, so you don't have to worry about swelling. You maintain the 1/2 inch distance between those boards, and every 10th board where you have a grate, that allows for dissipation of water and uplifting forces when you have storm surge.
Mm-hmm. I'm going to recognize Tracy Benke, who has her hand up. Go ahead.
I'm muted. Hi, Tim, it's Tracy. Did you send in the updated WRP? There's actually a form, if you recall, part of the EAS that city planning had wanted the latest version that went with all the flood elevation documents you gave.
No, I didn't send in a whole new one. We had submitted one, and we had submitted supplemental information to that specifically for just those 2 paragraphs within that document. If you need a whole new one, certainly happy to do so. But it's really just 2 of the policies where paragraphs needed to be revised. That was in policy 4.3 and also policy 6.1.
Okay, yeah, I believe they wanted the updated form as well. So,
Okay. Everything else on the form would stay the same. That's the only change that I'm aware of. But we'll go ahead and do that and get that in promptly.
okay, thanks.
Okay, so then if I'm understanding, well, maybe Tracy can help clarify this. So we still have, DEP is still asking for the phase 2 work to actually be performed.
Yes,
Otherwise an E designation would be possible, or?
it would be possible. However, since DEP already approved the work plan and HASP, generally it's easier to continue that route because otherwise it might have to be updated by OER. And I'm not sure, not everyone wants an E designation.
Right, okay. Okay, so, because another thing that we talked about is because you have a DEC, need to have a DEC approval, and DEC said it had no objection with us moving forward independent of them. But Mr. Judge and Angelino, you should be aware that if DEC requires any kind of modifications, you will end up having to come back here for, at the very least, a letter of substantial compliance, but sometimes even an amendment. So to the extent that you can simultaneously move further along with DEC, is Army Corps also involved in this case?
Yes, Army Corps would also be receiving the joint application.
Mm-hmm.
And we believe that this will be covered under a nationwide 35.
Mm-hmm. Okay. So to the extent Army Corps and DEC require changes to the project, after we presumably grant it, then you would have to come back for either a letter of substantial compliance or even an amendment. So to the extent you can get further along on this as you finish up your DEP, your phase 2 testing and the WRP, that would be ultimately better for you, I think. Commissioner Sheta also has his hands up, so go ahead.
I just have a comment very quick because I just listened to something that for me, it sounds like it's an initiation for a design error. I would recommend, I'm not sure who's going to perform the structural design for this, but what I heard about the spaces between the boards going to be dissipating the water, that's fine. But the uplift force, and I didn't have to say this, but I just wanted to alert, the uplift force because of these an inch or half an inch space is not going to be dissipated, especially if we're talking about the wave force, the uplift because of the wave force. So if you're conveying a design clue to the structural engineer, please do not convey that. This is not entirely accurate. If you're designing this and you're going to count on your assumption that the uplift will not be there, again, I want to assure you that this is not accurate. You can have some uplift. The space of an inch or half an inch is not going to be enough to immediately dissipate the uplift, especially the one that's coming from the wave action. I just wanted to make this clear.
Mm-hmm.
Thank you. I appreciate that. The other thing is that every 10th board is a graded board, which has far more open spaces. It's essentially, there have spaces which are, I believe they're 1/8 inch, and it's a grid. And so that allows water to also come up every 10th board. And yes, you're right, with wave action, it's not necessarily going to obviate all of the uplift force, but it certainly helps dissipate it quite a bit. And with all those extra attachment points, we think that that'll probably do it. And I've been working with the engineer on that. But thank you.
It does, and you know what? You might need to give peace of mind and just design for the full uplift, because the complication of like getting this right is really high. And I would suggest, it's up to you. If you wanna do it that way, just ignore these spaces and factor in the total uplift because of the wave action, and it's going to cost you probably a pile or two to carry that uplift, which is not a big deal.
Thank you. I will pass that along to our engineer.
Thank you.
Sir.
Commissioner Shanda also has her hand up.
I had a question. This kind of design review, is this something that is done by Army Corps and DEC?
Yes, Army Corps and DEC will look at the final design plans for the structure itself. Yes.
Okay.
Yes. Okay. All right then. So really, I think the substantive issues that had to do with our aspect of the review are done. I think the drawings are all in order for us. Should I allow Mr. Chester to come in? Maybe he might have something to say. I'm going to admit him into the, and just in case he has something he'd like to add, he's connecting to audio. But in the meantime, the only things we have open are the environmental review issues.
We understand that, Chair Perlmutter, and we also understand your comment regarding DEC.
Okay,
And
so
we're well aware of that.
in sort of an ideal world, when would you want to come back to continue this hearing?
I'd love to come back to an ideal world, but
No,
I don't know. I guess, Tim, I mean, it depends on two things. One, the completion. We don't have the green light yet from the governor to do the testing. We believe the testing is, we're the only, there's only residential use, at least for a quarter of a mile away from this site. We believe the reason the request for the testing was because there were 2 in-ground residential oil tanks within a quarter of a mile of this site, and that's what triggered it. We don't believe, based on that there's any mitigation to this site, but we understand that we have to do the testing and we're doing it. So we think that at the end of the day, that it's going to show that there's no contamination of this soil. But we have to go through the process. We don't know when we're going to get the green light, so I can't give you any indication. I'd like it to be sooner than later because it is a university and they're trying to plan for their, with everything else, they're trying to plan for when these teams are going to be able to use the site and do the rest of the renovation work in order to make it possible for them to occupy the site.
So if we put you on for an August date, you think that's, I mean, who knows when, but do you think
Yeah,
that's?
if it's not too much difficulty, is it possible to close the hearing at this time, or is there?
Because we have open environmental.
You have the open environmental.
But in August, who knows, maybe we would be back to doing closed votes. So, or for instance, today.
I'm thinking, is it possible to do an end of June hearing? I know that's an inconvenience setting it on the calendar, but it would be, in case we get lucky and things move forward, that we may be able to get, be in a position where we have those issues closed so that you're in a position to close your hearing.
It may not be end of June, but we could probably find something in July.
That would be fine.
Okay, all right. So I'll make a note. Okay, and Commissioner Shanda had her hand up.
Yeah, I had a question going back to the question. If Army Corps and DEC will be reviewing some of the design detail, and that may change some of the plans, is there any way we can identify what aspect of the plans would be reviewed by DEC, and we can put a note in the plan that says subject to final review by DEC? Because most of the review would be mostly along the waterfront and the pier plank. It won't be the building. It won't be in the upland section. Would it in any way change the WRP review or anything? I'm not that well versed with the WRP process, so I don't know whether any of the elements of DEC or Army Corps review will change WRP's review process or our design plan. Our design plan is mostly related to, I think what we mostly care for is in the upland, also in the, like what's in the waterfront, but the waterfront is going to be completely controlled by DEC and Army Corps.
Right, but the point is that when they go to DOB, or in this case, I guess it's small business that approves this. Is that right still? Anyway, when they
Yes, I
go,
believe so.
right, then the drawings won't match. And depending on who the reviewer is, they'll say, wait a minute, your drawings don't look like the drawings that the BSA approved. So I know
Well,
you're
yeah,
suggesting.
right. So if we could have a demarcation of the area where DEC jurisdiction kind of drawings kind of overlays and some note to that effect. That's what I'm just saying.
Yeah, maybe. So you could look at that. I just don't really know what the scope of the review is or the potential modifications from those other agencies is.
Yeah. Tim, Judge, can you shed any light on whether
Yes.
you think that based on the conversations you've had with DEC, how much of a change is possible? Or that
It's-
whether
Yeah, I mean, mostly DEC and Army Corps are looking at what are the impacts of the in-water work, and to make sure that the in-water work does not have any negative impacts on the benthic community and the substrate. So essentially the bottom of Eastchester Bay. So they're usually, they also comment on the design, such as making sure that things are resilient in terms of how the structure is put together. But they're not going to be particularly changing design parameters of the pier itself or the floating docks. They want to make sure that the floating docks cannot touch the bottom, and that they maintain a certain distance off of the substrate. You'll notice on the drawings that the floating portion of the docks, the concrete floating docks that are attached to the pier on the north side, those do not start until you have a minimum of 5 feet at mean low water. So we meet that criteria for Army Corps and DEC of staying off of the substrate. We don't have a lot of submerged aquatic vegetation in the area. It's primarily rocky, the substrate in the bottom, but that's certainly part of their review, is looking at it from that environmental impact standpoint. So that would be all of DEC's concern, is going from the bulkhead waterward. That's where we need to have DEC and Army Corps' approval. Part of Army Corps' approval is talking with NOAA, the National Marine Fisheries Service, and the Section 7 Office of GARFO, which is Endangered Species. So we've been in touch with both of those offices. We don't believe that we're going to run into any issues, and talking with the GARFO Section 7 office in Gloucester, they have told us that they believe, based on the information that we've conveyed to them so far, that we'll fall under the Not Likely Adverse Effect Program, the NLAA, which would allow Army Corps to expedite the review. So we don't think that we're going to run into any of those issues. We've already changed our original concept of how we were going to lay out the various docks and make sure that we could get the rowing shells and the boats, the sailing dinghies into the water, and have consolidated that and moved away from a small little patch of cord grass that's just north of the property. So we've taken measures already to try to reduce any environmental impacts, and we'll continue to do that. The other thing that we're going to seek from Army Corps and DEC is permission to sink an additional piling that will have an osprey platform put on the piling to provide a nesting site for osprey.
Uh-huh. Oh, interesting. Okay. Great. All right. So you know what? Maybe you could do it like this. Maybe you could provide us a set of drawing, because it's just one drawing, and you kind of put a dash line around the area that's subject to Army Corps and DEC and NOAA and all those other guys' approval. And that's what we indicate on the drawing, so that when we finally get through DEP review and WRP, maybe that'll be good enough for us.
Right. I mean, part of the WRP review, which we had addressed previously and continue to maintain, is that the building, the two-story building that is closest to the seawall, to the bulkhead, all of the mechanicals that previously had been on the first floor will all be put to the second story of the building, which takes it out of the flood zone. There'll be an open plan, as we've talked with the architect, to make sure that water can go in there. And what is stored there will be equipment for the sailboat. So you'll have booms and masts and other equipment, tillers and rudders. All of those are used to getting wet, so they'll be secured, but they won't, we don't have to worry if they get wet, and there will not be any mechanicals. So that if there is a storm, if there is that kind of surge, the building will have been, designed or refit for that purpose.
Okay, but did you understand what I'm saying in response to the
Yes.
suggestion from Commissioner Shanda? If you could provide us a delineation of the area that's subject to Army Corps, DEC, NOAA, et cetera, approval, and just indicate that and say, and write on it, subject to the approval by those agencies, then once we get the sign off from DEP and WRP, then we may be able to move forward on this application.
Okay, no problem.
Okay, great, thank you.
We appreciate that suggestion.
Okay, and then I'm going to unmute Mr. Chester, just to see if he wanted to add anything. Can you hear us, Mr. Chester? Not sure if he can hear. Anyway, if you would like to speak, please do. Otherwise, we are going to invite speakers from the public. If anyone is interested in speaking on this application, it is application number 2019-7BZ 3341 Country Club Road in the Bronx. Dial-in number 646-558-8656 and the meeting ID 469-050-895. We'll just give them a few seconds, 30 seconds. Mr. Chester, would you like to speak? No? Okay. So we'll try to put this on for a July hearing, okay?
Thank you very much.
Okay, thank you.
Thank you.
Okay.
Thanks for
Stay
calling.
safe, everyone. Thanks bunch.
Okay. The last item is item number 7, 2019-76BZ, 1973 East 16th Street, Brooklyn. Laura Altman is the applicant.
Hey, there she is. That was
You
good.
got her? Okay.
Yeah. Okay. You state your name when you can hear us and turn off your video, your YouTube, I mean.
Okay, Lyra Altman.
Great.
Okay, let me swear you in.
Hold on, I can't
Oh,
hear
sorry.
you. Bear with me a second.
Oh.
Having a technical difficulty here.
Hey, there she is.
Yep, I'm just trying to mute
Got her?
this.
Okay.
Yeah.
I'm just trying to check the volume on YouTube. There.
You have to just turn it off.
Yep, I just wanted to make it go away. Now I'm back.
Okay, good.
Okay. Okay, so raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Of course.
Okay, please proceed.
Good afternoon. We listened to your executive session and heard your comments, and I believe my architect, Phil Harris, will also be calling in now. With respect to the error on the existing plan, the error wasn't actually on the plan itself. It was the calculation of the first floor. He reran the calculations, saw that the numbers weren't exactly right, and corrected that number. So it wasn't something you would visually see on the first floor. It was just a calculation.
Sorry, which number, which calculation?
The
What?
first floor area on the existing, not the proposed.
Oh, okay.
So that's now been corrected. And lastly, with respect to page A11, you are absolutely correct. We would be glad to make that change to match the remainder of the pages.
Okay, the person who just dialed in at 979, please turn off your video, your YouTube, because we get feedback. There you go. Please turn off your YouTube video. Okay, and so that's the area to be legalized in A11, right? That
Correct. It went just slightly further back than it should have.
right, okay. All right, so then if you could provide us with those corrections to the drawings and a cover letter that just says specifically what is being corrected and bubble the corrections.
Okay, so just do one correction. It's just that page A11.
Oh, okay, so when you're talking about the calculation between what was it, the calculation between the existing and the proposed? What?
Is calculation of the existing floor area on the first floor. We
Mhm.
corrected it in this recent submission.
Ah, okay.
And Vice Chair Shonda had addressed that at executive session, so we just wanted to respond to her.
Okay. Okay, good. So it's just the correction of A11 indicating the scope of the so-called area to be legalized then, okay?
Correct. Would you like a bubbled set as well, or would that be unnecessary given the change?
I think it's unnecessary because there's only one, sorry, something threatened to spill. The correction, okay, no, that's okay. So we're only correcting that one hatched area to be legalized. That's good enough. Okay, so how quickly could you turn this around?
I'm hoping that my architect is on the line and can answer that. Phil Harris, are you there? Is there somebody in the waiting room? Because there should be.
He's unmuted, 979. Hello? Yes.
Yeah, hello.
That's Phil. That's our architect.
State your name, please.
Philip M. Harris.
I have to swear you in. Do you
Okay.
affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Okay, please proceed.
So the
So
question,
how quickly can you make that change?
Yeah, no, I heard what you said. That's absolutely true. We'll make that on A11.
yes,
It was just a typo. We actually did catch it, but for whatever reason, it slipped by on the print.
okay. So in other words, you've already made the change. Can you submit the modified drawings really quickly?
Yeah. As fact, as quick as a very simple thing. Within a day or two, I can get that right back in. No problem.
Great. All right. So please do that. And then we will let you know when when we can put this on for decision. But in the meantime, we are inviting members of the public to call in, as I'm reminded by Mr. Steinhaus. So this is application number 2019-76BZ, 1973 East 16th Street, Brooklyn. And the dial-in number is 646-558-8656. And the ID number is 469-050-895. And since we only have to make a tiny correction to the drawings, we can close this in a minute when we allow chance for people to call in. Okay. So seeing no one calling in, I'd like to make a motion to close.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Shabeta? Oh, he's muted, the poor guy. Okay, hold on a second. I can't do it. Okay.
Okay, aye.
Thank you,
I'm
Commissioner.
beginning to think that it's by design.
Sorry.
So this case is closed for decision, and there is one plan to be submitted.
Correct. Well, a set of plans, but
A
one
set of plans, sorry.
corrected. Don't forget to sign and seal, but you're submitting the entire set of drawings. Okay?
Hello.
Thank you very much. We'll make sure to submit an entire set, and please stay safe and healthy.
Thank you.
Thank you.
Bye.
Okay, this concludes the public hearing for April 20th, 2020, the 2 p.m. session. Do you want me to call the cases for tomorrow or not
Yeah, why not?
necessary?
That's good.
Okay. So tomorrow, April 21st, 2020, in the 10 a.m. and the 10 a.m. session, the following cases will be discussed with the exception of 2019 184 BZ, 4520 83rd Street BZ, 83rd Street Queens. That case is being adjourned. 2019 93 BZ, 3203 Bedford Avenue, Brooklyn. 2019 268 BZ, 1938 Coney Island Avenue, Brooklyn. 2019 271 BZ, 37 Manson Avenue, Staten Island. And for the 2 p.m. session, the following cases will be discussed: 2019 202 BZ, 2218 East 3rd Street, Brooklyn. 2019 272 BZ, 600 6th Avenue, Manhattan. 2019 296 BZ, 84 Franklin Street, Manhattan. And 2019 297 BZ, 588 5th Avenue, Manhattan. Those are the cases to be discussed at the 10 a.m. and 2 p.m. session tomorrow for April 21st.
Okay, thank you everyone for your participation, and talk to you tomorrow.
Bye.
Bye.